Present.
Alex Leader, President.
Mr. Neil Hoffman, Board Member Present.
Annie Curtis, Chief Inspector, present.
Gloria Alexander, Office Manager, present.
Deborah Blasco, Accountant, present.
Vince Jimno, Executive Director, present.
Sarah Bradley, Deputy Attorney General.
Rosemary Reynolds, Deputy Attorney General. Present.
Thank you, everyone. I'd also like to take a moment and introduce Kathy Ditzler at the back of the room. Kathy Ditzler is our outgoing president for the State Board of Cosmetology. And at this time, if we could all please stand for the Pledge of Allegiance. Kathy, if you'd like, maybe have the honors of you start the words.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I do want to also publicly thank Kathy for her service to the State Board. She did an excellent job over the last couple of years as a board member. And, while she is with the staff, she is deeply missed for her support and for the work that she did as a board president.
Here, here.
Let's kind of move the meeting forward. We did add a general comment area to the beginning of the meeting, as well as a general public comment area at the end of the meeting. So at this time, if there was anybody who wanted to stand and address the group, now is a good opportunity to do so before we proceed into the remaining part of the meeting. Did anybody have any questions or comments from the public area? Okay, with that being said, we'll move forward for the consideration and approval of the agenda and its posting. Ms. Glasgow?
It has been posted in accordance with open meeting law requirements.
I would like to take a vote on just approving the agenda and its posting, if I might have a motion. And I may have a second. Thank you. Is there any discussion prior to the vote? I did have one question. I wanted to double check. Who is the final authority on the agenda for the drafting of the agenda? Ms. Blasco?
For the drafting,
For the final draft.
Vince?
Mr. President, generally as I am, with consultation with the board president, I'll share there's items that are appropriate, and if there's items that need to be removed for whatever reason, or additional items that the board president sees necessary.
So that final authorization to approve the agenda is I'm sorry, who?
It's myself,
Okay,
Vince Jimno, with consultation with the board president.
great. And then I'd like to move to the vote, please. All those in favor of approving that agenda and its posting, say aye.
Aye.
All those opposed? The ayes have it. As we move forward, the consideration and approval of the board meeting minutes from our last meeting, October 24th. And then we had a subsequent meeting on November 21st. It was a hearing for those of you who were present. So we're going to take a look and consider both of those. May I have a motion for the consideration and approval of those two sets of minutes?
I'd like to motion
Mr. Hoffman,
both of those minutes.
and then may I have a second? Ms. Essinger? Are there any discussion on those minutes or on either of those dates? All those in favor?
Aye.
All those opposed? The ayes have it. Both of those are approved. And those will be submitted, Ms. Glasgow, to you. At this time, we're going to begin the disciplinary hearings. When your case is called, would you please step forward and then take a seat at this table. We have a court reporter here, Mr. Nelson, and he will swear in the witnesses with your right hand raised. And he will also note and take down everything that is said. So if there's any questions, there's a record of what took place during today's meeting. But he can only take down one person speaking at a time. So if at any point where two people are speaking, I will interrupt you and ask that just one person speak at each time. So please recognize the importance of that. In this type of disciplinary action, the state goes first, and that will be either one of our attorney generals that are present, the deputy attorney generals present. And then you will be given an opportunity to ask questions of that state's witness. After the state has completed its case or introducing the case, then you will be given the opportunity to present your story or your side of the events. The board may also ask any questions at that time. So I guess I should also interrupt, and if anybody has their cell phones turned on, if you could please take a moment to look at those and turn those off. And then subsequently, after all the questions have been asked and answered, then the board will deliberate and make a decision. Are there any questions? Our first appeal is a citation, the clip joint with Eduardo Raul Cervantes. Did I pronounce that correctly? Is Mr. Cervantes present? Okay. At this time, then, I'm going to give him the opportunity to still attend the meeting. So we will postpone that rather than making a decision at that time and see if he can still have the opportunity to appear. I'm going to move item number 6 to item number 11. So we will come back to that if he's not present at this time to still give him that opportunity. We'll move forward to the appeal of citation touch. Pardon me, yes.
Oh, I'm sorry. I thought you said number 11. You want to go to number 7.
Yeah, I'm just going to move number 6 to the end of those appearances, so it would replace item 11.
That's good.
So we're kind of at number 6, even though it's titled number 7. Touch Salon and Spa. Is it Shay Sarfati, the manager? Or did I pronounce that correctly? So 2 no-shows. Okay, well, we're going to make that item. We're going to move that just before item 11 as well. So we're going to give them about 5 minutes, because it seems like we might be moving forward quickly. So we're on that page 2 of the agenda with a complaint and notice of hearing, the Nevada State Board of Cosmetology versus Shadia Beauty Salon with, is it Shadia? Shadia. Yes. Kumaran, is that correct? If both of you would please step forward. And at this time, if you could raise your... And if you'd stand, and you'll be sworn in by our transcriptions.
Let me swear the interpreter first. You solemnly swear that you will correctly interpret these proceedings to the best of your ability, so help you God. Yes, thank you. And you'll translate the interpretation. This oath, you'll translate the oath. Do you and each of you solemnly swear or affirm that the testimony you're about to give before this commission will be the truth, the whole truth, and nothing but the truth?
Mr. President,
Yes.
please know that the interpreter is not a court interpreter, and we were not notified until justice.
So, sir, you'll have to speak up.
Oh, okay.
So we can hear you. And even though you're speaking a different language, please feel free to speak up. Okay? And then, sir, how are you related to Ms. Yumaro?
I work at the salon,
You work at the salon.
and I'm a registered cosmetologist.
Are you the cosmetologist in charge of the salon?
More or less, yes. Not officially, but
Mr. Chair, just so the board is clear and aware, I will be presenting the case today, and my colleague Rosemary Reynolds is here to advise the board as we go through this process. So she's the one that you'll want to ask your procedural questions to, and she'll help you with those things as we go forward, okay?
Thank you.
All right. My first witness would be Mr. Jeffrey Green. And the record should reflect that I'm showing Mr. Green and the respondent a copy of what's been pre-marked as State's Exhibit 1, which is the complaint notice of hearing that's been filed in this case. And Ms. Kumara, do you recognize that document?
Yes.
And did you get a chance to read it? Okay. I would ask that the complaint notice of hearing be admitted as State's Exhibit 1.
Pardon me?
So admitted.
Oh, it is so admitted. Is that the copy that we've already received?
Yes, I think you do have a copy.
Okay.
This one though is marked, so.
And am I correct to say this is Exhibit 1?
Exhibit 1, yes, it should be marked that way on the bottom. Mr. Green, can you please give the board a summary of why we're here today on this case?
Yes. Ms. Umaron has had 4 citations as a salon owner for allowing unlicensed activity in her salons. The first was June 2nd of '06. Ms. Padilla wrote a citation to her for allowing 2 unlicensed females to work on the public at 1942 East Charleston Avenue.
Mr. Green, you need to allow the translator an opportunity to translate what you're saying. So, kind of after a sentence, give him a chance to translate.
And you can also go ahead and as he's speaking, it's okay for you to interpret.
yes, it is. And Ms. Umaran understands a lot, but he's speaking that she has a bigger difficulty, so she wants me to be here when she, to help her when she's going to answer questions.
I would like you to understand everything that's being said.
Yeah.
So if at any time you are not aware of what is being said, could you kindly raise your hand or indicate such, or let your interpreter know that you need to have that interpreted for you? Mr. Green, will you continue? Allowing time for translation.
So the second incident occurred July 14th of 2006. Inspector Padilla went to a salon owned by Ms. Umaron at 6172 West Lake Mead. And at the time, there was another unlicensed female working on public at that salon. The third incident occurred April 23, 2009. I was the inspector conducting an inspection at that time and observed an unlicensed female working on the public. And this incident as well was at 6172 West Lake Mead. Now, these 2 salons that are referenced in the first 3 incidents have subsequently been sold by Ms. Umaron. The last incident occurred August 10, 2011. The Inspector Fitzgerald, conducting a routine inspection, observed an unlicensed female working on the public at 6121 West Lake Mead. And at this particular salon, this was the first offense of unlicensed activity. For each of these events, citations were issued to Ms. Humeron and to the unlicensed people. And that the accumulation of these violations is what brings us here today.
Thank you, Mr. Green. Could you please, just again, just to make sure that Ms. Humeron understood, could you please just give us a brief summary of the first citation again? I know that's when we were starting, and that way her interpreter can interpret that, so she can be sure she has understood that one.
On June the 2nd, 2006, Inspector Padilla observed two unlicensed females working on the public at a salon owned by Ms. Humeron at 1942 East Charleston in Las Vegas.
Thank you. And Mr. Green, did you prepare a report regarding this case?
I did.
And I'm showing you what's been pre-marked as State's Exhibit 2. Do you recognize that?
Yes, that is the report.
Okay. And the records show that I just gave a copy of Exhibit 2 to Ms. Humeron. Do you have any objection to that being admitted? I would ask that State's Exhibit 2 be admitted.
So admitted.
So, Mr. Green, I think you said that citations were issued in all four of these instances.
Correct.
And those citations been paid?
I know that the first three, the one from June of '06, the July of '06, and April of '09 have been paid.
Okay.
I cannot say if the one from August 2011 has been paid.
Was the citation from August 2011 appealed? Did she file a notice that she wanted to appeal that?
No, but at the time, because of the cumulative number of citations, she was advised that a complaint would be filed before the board.
Okay.
Did you have any questions at all so far on the translation? No, thank you.
No.
Ms. Pratt?
Thank you. Mr. Green, I'm now showing you what's been pre-marked as State's Exhibit 3. Do you recognize that? And what is that?
This is the inspection report and citation pertaining to the first incident in June of '06.
Okay. And can the record reflect that I'm showing a copy of State's Exhibit 3 to Ms. Humeron? Do you have any objection to that being admitted, Ms. Humeron? I'd ask that State's Exhibit 3 be admitted.
So admitted.
Mr. Green, can you tell us what the violation was in this citation?
Yes, the violation was of Nevada Revised Statute 644.360.2, which is an owner allowing unlicensed activity in a salon that they own.
And was Ms. Humeron present when this citation was issued?
It appears that, I was not there, this was done by Ms. Padilla, but it appears that Ms. Humeron signed the citation and the inspection report.
Okay. All right. Moving on, I'm showing you what's been pre-marked as State's Exhibit 6, which I think I'm going to need to amend my numbers. Do you recognize that?
I do.
And what is that?
This is an inspection report and copy of the citation issued in July of '06 by Ms. Padilla for the second incident that we spoke about.
Thank you. And can the record reflect that I'm showing Ms. Humeron a copy of what's been pre-marked as State's Exhibit 6? Do you have any objection to that being admitted? I would ask that the document marked as State's Exhibit 6 be admitted, but let's renumber it to,
4.
yes, thank you.
So admitted as Exhibit 4. And at this time, I'd like to ask a question of Ms. Reynolds.
Yes.
I did sign the notice of consent decree on July 6th. Does that preclude me from hearing or voting today on their... And then I also signed on Exhibit 4 the notice of consent decree for the October 6th. Yeah.
That should be fine as well.
Thank you, Ms. Brown.
Mr. Green, can you tell us again what the violation was on this report of establishment?
This violation was again of NRS 644.360.2, which is an owner allowing unlicensed activity in their salon.
Okay. And I'm now showing you what's been pre-marked as State's Exhibit 7, but I'm going to renumber that one as well. Do you recognize that?
I do.
And what is that?
This is the inspection report and copy of citation for the third mentioned incident, which took place April 23, 2009.
Okay. And can the record reflect that I'm showing a copy of what's been pre-marked as State's Exhibit 7 to Ms. Humeron? Do you have any objection to that being admitted? I'd ask that this exhibit be admitted as State's Exhibit 5.
So admitted.
And Mr. Green, what's the violation listed in this report?
This was the third mentioned incident that we spoke about, which occurred April 23 of 09. It was a violation, again, of NRS 644.360.2, which is an owner allowing unlicensed activity in their salon.
Okay. And the last exhibit that I have is pre-marked as State's Exhibit 8, which I'll also be changing. Do you recognize that?
I do.
And what is that?
This is the inspection and complaint report for the fourth incident that was referenced, which took place August 2011.
Okay. And may the record reflect that I'm showing a copy of what's been pre-marked as State's Exhibit 8 to Ms. Humeron. Do you have any objection to that being admitted? And you've seen all these documents before. Thank you. I would ask that State's Exhibit marked 8 be admitted as 6.
So admitted.
And I apologize for the renumbering. Mr. Green, can you please tell the board what the violation was for this most recent citation?
The violation was the fourth reference incident where Inspector Fitzgerald observed an unlicensed person working, and the violation was for the owner violating NRS 644.360.2, which is allowing unlicensed activity in the salon that she owns.
I have no further questions for Mr. Green at this time, although I do reserve the right to recall him for rebuttal.
Thank you. At this time, if you have some questions of Mr. Green, is he want to answer?
No.
None at all?
No.
All right, now is an opportunity for you to address Mr. Green or to us, and perhaps give us an opportunity to explain yourself.
You should have the board ask
Questions of Mr.
with
Green?
this
All
board
right,
there.
I'm sorry, just another few moments for you. I'll give the opportunity for the board members to ask questions of Mr. Green first. Just another moment. Members of the board, are there any questions for the inspector? had a question, Mr. Green. In the NRS 644.360, there's number 3, which entitles the salon owner to rent or lease space to a healthcare provider. Was there any mistake made that this was a healthcare provider rather than unlicensed activity?
No, all of these were incidents documented cosmetological services being performed on the public.
Thank you. I also noticed that twice there was a Maria Perez noted as the receiving the civil citation. Was that the same person receiving the civil citation on 2 separate occasions?
What were the 2 dates that you mentioned?
The first one is June 2nd. Maria Perez was issued a civil citation CCSP 114. And then on 4/23/2009, Ms. Rivera Maria Perez.
It appears that it was the same person. If you look at the 2 incident reports, the one for June of '06, where it indicates Ms. Perez, it gives a date of birth of 7/16/61.
And those were the same, roughly, approximately the same individual?
It appears that way. I couldn't say, but it looks like the date of birth is the same and the name has similarities.
Thank you, Mr. Green. Any other questions of Mr. Green? Thank you. I'm sorry for the delay, but now is your opportunity to ask questions of Mr. Green.
Que ahora hay muchas oportunidades de preguntar a la tiene o al señor Green. I don't have any questions. I know that I was cited because of I did wrong.
So did you know that the other times that you did wrong, that you keep repeating it?
Si se refiere a tema, pero lo seguía repitiendo. The reason why I repeated it is because I couldn't find licensed people to work.
Are you licensed yourself?
Yes.
Please.
Can you explain to me why you would be licensed in the state of Nevada to work on somebody's hair?
Que si le voy a explicar por qué.
Could you explain to me why we require a license in the state of Nevada?
Que si le puede explicar por qué se requiere una licencia en el estado de Nevada. For client safety, and I really don't know.
Mr. Chair, I believe it's also her time to present her case, and she has things she'd like to say without board questions, so she can give you a statement or call other witnesses, whatever she might have.
Thank you. So absent any other questions that you might have of Mr. Green, now is an opportunity for you to explain your side of this story.
De la oportunidad para que explique su lado de la situación. Si le quieren hacer preguntas a él, si quiere explicar. No, I have no questions, but the reason why I continue to repeat is because I haven't been able to find people to help me at the salon, and I can't handle the salon all by myself. And that's the reason why I've been selling the salons.
We have schools, we have school owners here, that if you would contact the schools, I'm sure they would help you. There are so many people out there that have licenses that do not have jobs.
Okay,
You could run an ad in the paper. I don't understand why you feel you have to hire unlicensed people, which continues to bring you in here to us and fining you, which then you close your salon and have another owner. You change ownership.
I have gone to the schools, and I have had people people come in, but the reason why I have not retained them is because they are not really prepared. They don't know how to do what's required.
But an unlicensed person knows what's required?
Pero personas sin licencia. Unfortunately, some of the people that I have worked with that don't have a Nevada license do know more than some of the people that have come in with licenses.
To the best of your knowledge.
Hasta lo mejor que te sepa. Working with the public, yes.
Can I ask you a question? Is it proper, or is there a way to, I'm assuming that if you hire unlicensed people, you're not abiding by all the laws. So I'm assuming you don't have Nevada licenses, state licenses, city licenses. Are you paying taxes on these people? Are you paying them in cash? Is that any concern of ours? Is that anything? It's none of our concern.
It's not, that's outside your jurisdiction.
Okay.
With their ID number, I have reported them and they have paid taxes.
Not that it matters to us, but thank you for offering that.
Pues gracias que no tienen algo de ello.
I have a question. If the staffing and employing of salons is a problem, why do you continue to open them again and again?
Que si tiene problema, porque continúa abriendo salones.
Porque pensé que en una mejor área más fácil y más bien para trabajar, porque al principio no metía nada en lo mismo, porque están muy peligrosos.
Because I felt that moving to a better area, it would have been easier to obtain licensed people. At first, people didn't want to work at the east side because they felt that it was more dangerous.
Did you have anything else to add?
Que si tiene algo más que quiere agregar. At this moment, I feel very badly. I recognize that I did wrong, but I no longer own the salon, and the people that are working there are licensed.
Are there any other questions?
I don't have any questions for her.
Please.
What is the maximum fine that we can charge on something?
I think you want to wait until you've
Okay, I don't
made
make
a
that
finding. You haven't made any findings yet, and Ms. Reynolds will help you with that when it's time.
Ms. Curtis.
Yes, I'd like to also enter into consideration. We've received an application to change the ownership at 6121 West Lake Mead Boulevard, number 125. We have not been able to do that because Shadia is still on the lease. So that needs to be in consideration also.
So does that need to be entered in as an exhibit number 7?
I'm sorry. An application to change?
To change the ownership. We have an application to change the ownership. We received in September, but we've not been able to make that change because she still appears on the lease.
Is that the last?
If that's relevant to the board's decision, I guess it can be admitted. I'm not sure.
Well, because it was brought up, should it be?
I think it's relevant.
Is that the last location?
Yes.
The latest location?
That's still open.
Okay.
So then let's admit that as Stacy Exhibit 7, unless Ms. Moran has an objection to that.
Ms. Curtis, she should see that to make an appropriate decision. If you'd hand that to her, please. She should acknowledge that she's aware of what that document is so she can object properly.
honest, I do remember this. We did this. Elizabeth Laga is the owner of the salon.
Does she have any objection with it being introduced as an exhibit number 7?
Que si tiene objeción de que pongan eso como well, no.
No.
This is an application to change the ownership.
Okay, so admitted.
I'll get copies to you.
Thank you. Any other questions? If there is no other question, then now is an opportunity where we'll have a two-part remaining portion to discuss this. And the first part is to assess whether or not there is guilt or innocence regarding this.
Before you do that, you need to ask Sarah if she has any
I
rebuttal.
thought she answered, she said no.
Oh. Have
I
any
guess I
questions
didn't-
of her?
I said I didn't have any questions of Mr. Moran, and I don't have any rebuttal. This is to call. I would like to make a brief
Statement?
closing statement, and I don't know if Mr. Moran would like to make a brief closing statement as well before you.
Okay, thank you. Ms. Bradley, feel free.
Thank you. Basically, what I would just like the board to see is that I believe the testimony today has shown that there has been a pattern of allowing unlicensed activity in Ms. Himura's establishment. And so based on NRS 640-4430, we would submit that there are grounds for disciplinary action by the board. I would like to remind the board, though, that we're not here to decide the underlying citations, as those matters have already been decided. We're just here to look at the pattern of unlicensed activity and determine what we think is appropriate based on that, should the board find that there has been such a pattern. And if you look at page 5 of your complaint notice of hearing, it does give you the parameters of what you're allowed to do when that's appropriate. Thank you.
Which exhibit had the complaint notice of hearing?
That is Exhibit 1.
Thank you.
And did you have any final comments?
Que tienen un comentario final. My final comment is that I decided not to continue at the salon, own the salon, or work at the salon. And that's the reason why I'm asking to please allow the transfer of ownership, because I do still have a 3-year lease of the salon property. And if I don't if I don't do the transfer, I might be forced to be penalized, or as far as paying, for the lease. And this is my safest way to not be fined, or have to pay the rent of the place. If somebody else takes over, they'll disagree. If otherwise, I have to do bankruptcy.
Are there any other questions or comments? Or did you have anything else that you'd like to add, Ms.
Yes,
Samara?
I have enough to have it.
Board members?
Are you practicing hair after that if you're going to give up the salon? And are you planning on keeping your license?
Me
gustaría mantener mi licencia como consultora, pero de momento no estoy trabajando como consultora, yo estoy en la escuela.
I would like to keep my license as a cosmetologist, but I'm not practicing right now because I am attending school.
Ms. Bradley, did you have any final comments, statements?
No, I think we would let the matter stand submitted.
Ms. Reynolds, may we entertain a motion to proceed with the administrative hearing and the findings? Is that this time?
At this time, yes, you would close the hearing and move to deliberation. established it. The facts have been proven, we just need to do that. The second part is then we would move to
The
say,
penalty phase.
yes, which violations have been proven, facts, then we do violations, and then you would do penalties. Okay?
Yes. So we all heard Ms. Reynolds' explanation. I won't repeat it, but I will entertain a motion.
I make a motion to find Ms. Shania Jimenez, I'm sorry.
License 24862.
Thank you. I find that she's guilty and make a motion to I'll second that motion.
With the discussion to that motion, I'd like to clarify.
I need the facts, we get a motion that the facts have been proven as alleged in the complaint, not.
Pardon me. Since the motion was attended to slightly incorrectly, we're going to move to withdraw that motion.
Thank you. My second.
Would you like to try that?
Yes.
Okay.
So,
You can address it by the license.
you can say facts 1 through however, whatever number you like. So if you think they've all been 1 through 28 or 1, 2, and 6, whatever you think. Okay, I make a motion to find the licensee should I give that Go ahead, Neil.
I make a motion that facts 1 through, do we determine as 28, are factual, need to be entered into the record as factual.
Oh, I second that motion.
Are there discussions to the motions of the factual complaints? Then I'd like to ask for the vote. All those in favor say aye.
Aye.
All those opposed? That motion's been passed. Now that it's been established that those facts are facts, they've been proven, then we're moving to, pardon me,
You're moving to violations of law on page 5.
and that is the NRS 644.360.2. I'd like to entertain a motion.
Well, I have a question.
Okay. You've got 2 violations of law that are stated in the complaint. First claim for relief and a second claim for relief. Again, I'm on page 5 of the complaint. You take each of those separately and you determine whether or not, based on the facts that you have just found, whether or not those violations have occurred.
So you want us to say them individually?
Yes.
And before that motion is made, those are 644.360.2 and 644.431A.
That's only the first claim for relief. The second claim for relief is 644.4301A.
And they have to be made motions all separately?
Yes, it's better for the record if you consider them individually.
So we have 01K and the 0B, is that what you're saying?
You have 431K, which is the second claim for relief, and if the first claim for relief is 644.4301A, she's actually violated 644.360.2, which is a ground for disciplinary action pursuant to 644.4301A. That's what's stated in the complaint.
Okay, now may I ask a question about mine?
No.
Not yet.
So you just want a motion on the 644.360.2?
That those have been violated.
Correct.
The first claim.
Okay, I make a motion that she has violated 644.3602.
I second the motion.
Are there any discussions? All those in favor? All those opposed? The motion has been passed. The second motion.
Make a motion to move, to
Oh, yeah, that's good.
Make a motion that we fine her for 644.3018.
Is there a second?
I second the motion.
Are there any discussions? I'd ask for that vote. All those in favor?
Aye.
All those opposed? That motion carries. Is there a third motion?
I make a motion that we fine her for 644.30 C and K.
Is there a second?
No C and K on it?
644.4301K. 1K.
1K. 1K. Okay.
Oh, would you mind just repeating that?
Okay. I make a motion that we fine her for 644.4301K.
Is there a second?
I second the motion.
Find her, in your motion, you need to say whether you're finding her guilty or not.
Finding her guilty.
I second the motion.
And is there discussion or clarification needed for that motion, Mr. Nelson? All those in favor, say aye.
Aye.
Those opposed, that motion carries.
So now
Now,
that you've
the
found.
penalty phase.
Yes.
There have been 3 motions in violation of 3 different NRS. So there will be 3 motions, or there will be 1.
There's some confusion, I think. The first claim for relief has 2 statutes. And so that's one guilty finding. And the second claim for relief is the second guilty finding. The way it works is that when you violate any provision of NRS 644, you are possibly going to receive disciplinary action. So what you found to be true was that she did violate NRS 644.360 sub 2, which is grounds for disciplinary action pursuant to the next part. So violating a law in and of itself isn't necessarily disciplinary action unless you have the authority. Does that make sense? So there's 2, you make 2 findings of guilt, first claim and second claim. So you would only have 2 possible penalties that you're going to assess for those. And you can do it in one if you like. I mean, it's up to you. If you want to do one penalty for both, you can do that. If you want to divide it up into 2, you can do that, right?
Yes.
Is there an additional to the second claim of relief below that for that NRS, or is that just because it's been separated out?
Yeah, I mean, you made 2 guilty findings, and so you can make 2 motions of penalties if you want. It's up to you how you want to handle that. The only other possible option you may have, after you make the guilty findings, which you did, you'll determine what the penalty should be. So that's the next part. And then there's also something to keep in the back of your mind. Since you've made a guilty finding, you can also assess costs if you like. And costs are also stated here. You don't have to assess costs, it's totally up to you. But once you make a guilty finding, that's when you can assess costs.
So, and that would be the third motion. I'm trying to understand that.
Typically, no. Typically, people, if you're going to assess costs, will include it as part of the first motion. If you can separate them out, it's up to you.
Would anybody like to give that one a shot?
This is my feeling on it, that I would like to see for each finding today that she be charged $2,000 plus court costs, because it seems like this is something that is continual. And then once she paid her fine, then that would allow her to sell her salon and move on. But I think $2,000 per incident is, if I could charge more, I probably would charge more, because I think we're putting the public in harm's way by allowing unlicensed people to work on it. So that's my thought on it. And that, I would like to make that recommendation. Anybody else?
Would you like to put that in the form of a motion?
I'd like to make a motion that for each offense that she, claiming is charged $2,000 for each fine, for a total of $4,000 plus court costs.
For today's proceedings?
For today's proceedings.
I second the motion.
At this time, if there is any discussion, can I open the discussion for the translator? Do I open?
No.
No.
This is just the board's discussion, and if you would like to know what the board costs are, there should be someone here who can tell you.
Well, would you
that.
like to have a not to exceed?
Not to exceed is 1,500 enough, or
I think that's more than enough.
okay, what would you like me to?
It's up to you, but
I mean,
this case wasn't super involved for me,
Okay.
so, I mean, I can give a tally of my costs to the respondent within 15 days of the board's order.
Okay, and not to exceed $1,000. Okay. So,
Give it away.
and paid within 60 days? Is that enough time for you, or 90 days?
It's up to really her, what she,
Okay.
I'll get the cost to her within 15 days.
I would like to, I think 90 days should be sufficient to allow her to sell her salon and pay her phone.
So I'm just going to repeat that motion.
I'm not receiving a single penny in the transfer of the salon.
Not at this time, unfortunately.
Mr. President,
Yes.
I have clarification.
Please.
This is a house, a disorderly house type of complaint, meaning that the practices of the agency that we're pursuing this morning have not complied with the law on a routine and regular basis. Therefore, I've not heard any discussion of revocation or suspension, because the issue is it's repeating itself. I heard fines, but I wanted a clarification. What's the board's intent?
With her, in regards to her license?
Yes.
Well, can we have some discussion on that?
Because in other cases, you have revoked or suspended licenses for similar violations. And so I think Mr. Jimbo's just concerned about consistency of rulings and also making sure that you're aware of what your abilities are. If you're confused about that, you can read NRS 644.430, which tells you what you're allowed to do. Subsection 2.
Are we allowed to have any discussion on this?
Well, you made a motion. I don't know if there's
Well, we're in the
a
discussion phase, and there was a second, and now
Okay.
we're discussing it.
So you're discussing
yes.
the motion.
Okay, because what I'm seeing is that they're working without licenses. We can take her license away, but I feel that, I don't know how to handle that.
I guess for me, it's if we take her license away, she's going to be in the kitchen and
Yeah,
doing it
that's
legally.
Well, and especially since it's been explained to us that she's already not using her license currently, she's in school, so taking her license away.
I don't want her to have a business license, but it's not our jurisdiction. But she can have.
What about the license of the establishment?
She's got no
She's trying to
establishment.
sell.
Well, she can't work until this fine is paid, is that correct? She cannot work until this fine is paid.
Once she's got her license, she can work, unless you suspend her.
Until this fine, can I suspend it until the fine is paid?
The issue is she's not working. She's trying to sell the place. She can't sell it unless there's a new lease on the property, so she can't license it. So technically, the issue is her license going to be good or not with the board? And secondly, is the establishment's license going to be good or not? And the board has really not discussed any of those options. We've talked about fining her. So the issue I'm asking for clarification is, what does the board really want to be the final stage of that license? You want her to be able to work? What is it you're trying to accomplish?
Well, personally, I think that she shouldn't have an establishment license. And I think that she should pay the fines. And then if she is just in charge of her own license, working in a booth rental situation for someone else, that might be sufficient, because if we don't, if she doesn't have a license, she's not following the rules of the land, and there's no way to regulate that and keep the safety of the public, which is in our best interest at this point.
And I would
I'd like some sort of regulation.
also for me, my concern is that we have taken the license away before, yes, but that doesn't seem to stop the problem. What I really see stopping the problem is the fine, and that if her license was put on hold until her fine was paid, that should be how it should be, I think, anyways. I didn't realize it wasn't. But I think that fining, I think, is
amend your motion to include the suspension of both the establishment and the individual license until the fines are paid in full.
Yes, I would like to amend my
I
motion.
don't believe that you would have an indefinite suspension.
Well, I think she placed a time limit on the 90 days for the,
You're saying that her license is suspended for 90 days?
No, let's do for 1 year and give her a year's, we can't do 1 year? Okay.
Not for suspension. The suspension's less than 1 year. A revocation is 1 year or more, not to exceed 10. A suspension is done in a temporary situation. So, for example, in the real estate division, they frequently will do 30 days as sort of a penalty to somebody. It's usually done for a set time period. So the concern that Ms. Reynolds is speaking about is that if you say your license is suspended until you pay the fine, the license could be suspended for 15 years if they want to pay the fine. And that's the problem. You
I'd
can't
like to
have
suspend
it.
their license for 90 days, is that acceptable?
Yes.
How are they going to pay if I don't work?
And I think it would be helpful for me as I'm drafting the order if you could be more clear about what license you're talking about, because she has two licenses. She has an establishment license and she has a personal license. And so for me to know what you're wanting, it would be helpful if I could know that.
Yes, it would be for both licenses.
so a motion has been made, it has been seconded, the motion was amended. Would the person who seconded that motion like to second the amended motion? The amended motion included
Suspension of
the license for 90 days for both the establishment, the S12065, and the individual license, C24862.
It includes also the fine for 2018.
I'll amend the motion.
Or amend the second.
Sorry. Second the amendment to the motion.
Are there any discussions? Ms. Reynolds, is that handled to your satisfaction?
Yes.
Would you like to hear the motion repeated at all? No. So at this time, I'll entertain the vote. All those in favor, say aye.
Aye.
All those opposed? That order imposes discipline, and the findings of fact and those conclusions of law support that order is now going to be public record. Thank you. If you have some questions, you can speak with Ms. Curtis, or you can speak with Ms. Glasgow after today's hearing.
With that motion being second and accepted, what is the decision on the salon being transferred to someone else?
Well,
With
that
her
should
on the
happen
lease.
naturally, shouldn't it, Mr. Givno?
She's on the lease.
The establishment can be transferred if the person who's buying it establishes a new lease and meets all the requirements. That's not been offered up so far, is that the lease has got a new leaseholder.
Right.
So
So that's handled administratively,
that's
I'm to understand.
So I think Ms. Curtis has indicated that that lease has not been established for a new owner. And that's one of the requirements of getting licenses for this.
So with your intent to sell or sublet your establishment, once you have someone interested in that, have them apply, and that they will be handling that administratively.
She has the application.
That's correct. So once you have a subletter, you can bring that person to the office to fill out the appropriate establishment license.
All of that has happened. The owner of the building will not release her from the lease. That's the problem.
Unfortunately, that doesn't make a relevance to this decision today.
It's her responsibility to establish a lease with the owner of the property, because she signed the lease and guarantees the rental for that period. So unless the owner of the property releases her from the lease or is willing to transfer the lease to a new name, and at this point, they've refused to do that.
And that's why we do not condone unlicensed activity, particularly repeated 4 separate times, over 5 to 6 years. Thank you.
Mr. Moran, just so you know, there will be an order sent to you detailing the board's findings, and so you'll have that order sent to you. Okay?
Do we need a 5-minute break?
Yes.
We will resume at 10:05. We'll resume this meeting at 10:14. Picking up where we left off with the petition to hear Kathy and Bruce Hale, a hairy situation. Is it Mr. and Mrs. Hale? You're welcome to step up if you'd like. And this is requesting a variance to modify a cosmetological establishment in reference to NAC 644.375 in their place of practice of residence. If you'll state your names for Mr. Nelson, and he'll swear you in.
Mr. President,
Thank you.
the staff prepared a report for this petition. Mr. and Mrs. Hale have requested the variance to the requirements of a home-type salon. The history of this particular site was that they originally applied for an application, were advised of the requirements of the application for approval. They were desirous of a door that went into the residence. They were indicated by staff that was not in compliance, but they were in a hurry to get it open. They subsequently filed the application meeting all the requirements. Now they've come back with the request to open a door that is not part of the requirement. It is prohibited under normal conditions in a residential property. They're now requesting a variance to that requirement, which means they'd like to open a door into the residence from the establishment. Staff is recommending that option be denied on the basis it doesn't meet the normal standards and requirements of the code.
Thank you, Mr. Jimno. Do all board members see on that schematic what Mr. Jimno was referring to? Where the house is, where the walkway is, where the doors are? Are there any questions of Mr. Jimno before we address Mr. and Mrs. Hale?
I do have another set of drawings to kind of show more of the floor plan because I'm not sure what schematic you have in front of you.
Why don't you provide those to Mr. Jimno? And do I need to enter those in as an exhibit? No. No.
Like a hearing.
Okay.
It's just part of the record.
Okay. And so those were the same? Those were the
different diagrams. He's brought different diagrams. The diagrams that you've received were the ones that were submitted with their application for the petition.
And so are you changing the application?
No, we are not. I just wanted to have clarification on the floor plan and where the doors would be located if we was granted variance.
Okay. And Mr. Jimno, if I could just be real clear, they submitted a floor plan. The floor plan was corrected so the application could be approved, and now it's being asked to be changed.
That's correct.
Okay.
The original application, they wanted to have the door. Staff advised them that they could not have it unless there was a variance granted by the board. and they moved forward to license it with a door not installed, that it was sealed off. There's no access to the home. You have to go outside, go around. But now they're coming back after they've been licensed. They're asking for a variance to open that.
Like reinstall.
Yeah, they're now asking for, I'll be allowed to cut that open again after a door.
Thank you, Mr. and Mrs. Hale. Who would like to go first?
I will. First of all, like was stated, this is on a residence. This is our primary residence. We've installed the salon in accordance to a couple of salons that are in the county. The county is very rural. Apparently they were installed before the new NAC law was in effect, because we didn't know that you couldn't have another access and egress from the residence to the business. So we just it was part of the residence. We left it there, and then when we found out, we walled it in. But what we're requesting is to remove the wall and return the floor plan to the original floor plan. But what we'd like to do is to meet the spirit of the law is put a deadbolt on the door so it can be used when the days of business, when the salon is not open. The salon is going to only be open 2 days a week. So the other 5 days of the week, we'd like to use it, to utilize that doorway to have access and egress to our garage.
Is it to the garage or to the establishment?
If you see through the hallway, I believe you have, I don't have a copy of this for sure. I believe there's the doorway that goes into the garage.
Yeah, my phone.
Great.
Oh, I don't need that.
No.
So the initial schematic we have is the one that you applied with, where there's no door at the bottom of it going towards the house.
Correct. The door at the bottom actually is in the garage. It goes to the garage.
Okay, so where it says home, that's the garage, and then where it's labeled garage on the top of the schematic.
At the top of this one, it's labeled.
Maybe I can help. In the diagram, you'll see there's two diagrams in the paperwork we've been provided. One of them is the revised plan where they submitted a plan that complied with the requirements. If you'll notice at the bottom of that document, it shows house. That wall, there was they wanted an opening there, and that's what they were asking for now, a variance to allow that door to be opened up to the house, and the regulation doesn't allow that. It requires a total separation with no egress and ingress. Directly to the house. In other words, you can't go get in the kitchen, get a cup of coffee, come back through that door back to the shop. You have to go outside and go around.
Our point is that the salon's only going to be open 2 days out of the week. The other 2 days, we'd really like to utilize the floor plan the way that it was intended. And if we can meet the spirit of the law by having a deadbolt on that door for the 2 days of the week that the salon is open, that would be just fantastic.
Please. Yes.
So I understand what you're saying, Mr. Held. The challenge is in the law, and we really can't change the law. That would be something that the legislators would have to do. Interpreting the law, by putting a deadbolt on it, it would really take us out of what the law says. I think that is pretty black and white. It says you have to have a wall there, and it has to be sealed.
But you can grant a variance of the law, and that's what we're here for. We understand we're not asking you to rewrite the law. We're just looking for a variance.
Can I clarify, please? So what we're looking at today is NAC 644.375. That's a regulation that was drafted by the board effective 1980. It was later amended as recent as 1998. So just so we're clear, it's a regulation that the board drafted that has the force and effect of law. Should there be a change to the regulation, that is something the board can do after the board follows all the requirements for administrative rulemaking. The regulation does say in subsection 1 that the cosmetology may be practiced in private residences only when the rooms used are completely separate from any rooms used for living quarters. So that's what it says. The only possible authority the board has to grant a variance would be coming from NAC 644.040, which says deviation from regulations. It says in special cases upon application, the board will permit deviation from the provisions of this chapter if it finds there is good cause for deviation and the ends of justice so require. So in order for the board to change the regulation that it drafted, you would have to find that there's good cause and the ends of justice required. I would advise you as your legal counsel, the best place for you to be is to read your regulations, I think, as they are, except for in very limited situations and circumstances. So if the board does want to grant a deviation, it's something that we don't want to be doing all the time. It needs to be done really specially, and you need to make sure that there is the finding of good cause and the ends of justice.
Well, my concern is, Mr. Hale, is that if you sold the property to someone else who wanted to have that salon there, because that sounds like a desirable characteristic, but you're only open 2 days a week, but what would prevent you, the new owner, from being 7 days a week? And that variance would still be there. So, you know, that's kind of a hard thing. And going back to what you had said before, that you thought that maybe the NAC code, that 644375, may have been written after you modified the space. It's been there quite a while.
What I meant is there are a couple of salons in the county. You got to remember, this county is very rural.
900 people each.
I mean, we know everybody. It's so, to us, I mean, I don't really know what the issue is of having access to the other part of the house.
Why was that law changed? Where those houses were grandfathered in before? Why was that law changed that you couldn't have that door in there? Because I visited about 40 different
I can
salons.
think of a couple of really good reasons why it would be changed. I just lost my sister to breast cancer. So you work with a lot of chemicals that can permeate the house and maybe cause harm to your visitors. Also, too, I know there's a deadbolt there. But what if you accidentally forget to lock it and you have some little children over there? They go into the salon and they get into your chemicals and stuff. So for me, it seems this is a really good law, and it's to protect people getting into chemicals or getting those things, having to breathe them all the time.
Do you have a pet? Do you have pets? Do you
Just
have
one
pets?
little dog. Yeah, a chihuahua.
And I think that would be another reason, is that, you know, it minimizes the opportunity to have your pet go into your establishment. If you have an access or a throughway, there's a highly likelihood that that pet could get into your establishment, and that could be a fine for you too.
My dog isn't a house dog, but that's okay.
Why do you want the door exactly? Because of the flow of the house, you're saying?
Well-
Why would you be going in there if you're not working in there?
Could you go to the garage, through up to the garage?
I'd really like to show you the floor plan, if I can. I mean, what you're seeing is just a floor plan of the salon. You're not seeing a floor plan of how it interacts with the house.
Well, maybe what we could do today is make a ruling, and there still is an opportunity for Mr. and Mrs. Hale to appeal the ruling. Isn't that correct?
No, this is not a contested case. However, what you can do is there's a mechanism in place for you to challenge a regulation. So if you think a regulation should be changed, you can file a petition. Because today what you're asking for is a variance. But what you're asking for is a variance of a regulation. NRS 233B requires that there's a mechanism for you to do a petition to change or amend or repeal a regulation. So you could actually put together a petition like that, something in writing about why you think this regulation should be changed, and you can submit that to the board, and then the board would also So that would be your only kind of real option.
Mr. Chairman, Mr. President, the issue here is design, the regulation was established for health sanitation issues, as well as a clear separation of a business from a residence. And they allow the regulation to be crafted so a residence in a rural area or an acceptable zone, if there was some kind of mitigation factor or urgency or some issue that justified a variance, could be allowed under very, very special circumstances. In this case, it's a convenience issue at most. It should not be part of the house. And the way they do it in residential establishments is they clearly separate. That's the issue, is the separation. What they want is the variance that will allow them to now use the house as part of the zone. And that's exactly what the regulation was intended to stop.
And if Mr. Hale wants to give you another exhibit, I don't see why that wouldn't be allowed. I don't know if he wants you to keep it, but I mean, if he thinks you should look at something before you decide, I guess I would encourage the board to look at what he's got.
Did you bring something today?
I did, and yes. Would you each like a copy?
You have one?
Okay, the part dealing with the salon, a little more detail, and the rest of the stuff I just...
Maybe give mine to Mr. Junos.
Okay.
Sure.
Okay. The door that I circled, can I stand up here?
Sure.
Great. The door that I circled was an existing door, and that is the one that I would like to replace. The salon is totally separate over here from this hallway. The kitchen is here, our garage is here. When we come in, like I said, it's very rural. Our elevation is 6,000 feet. In fact, it was snowing when we left yesterday. So, and it is definitely a thing of convenience, but it's also an access and egress issue, I think. If there was a fire to break out, the patrons do have a place for access and egress. I'd like to state that as well. But this is the door that we would like to replace, and it would not really be accessing the salon. It is going through this hallway.
Has the fire marshal said that you need that door?
The fire marshal has not. But I haven't approached the fire marshal since we had to put the wall up.
How wide is this hallway? Is that a 3-foot? Or?
It's 7 foot.
It's a 7-foot hallway.
Correct.
So what is the standard requirement for a hallway? 3.5?
Probably something like that.
Can you divide that up if it's a 7-foot hallway, creating 2 separate walls, closing out the salon, closing out the garage, and creating your own hallway, like this way, thusly, creating a door here, maybe a pocket door, something like that?
Because there wouldn't be enough room for a door.
Okay, 7 foot.
Can I ask you, how do you get into this restroom here that's attached to the salon?
Through the hallway.
Okay, in the storage room?
Right, salon.
So you go from the salon through the storage room into the...
Correct.
Into the hallway.
Into the hallway.
Go to the bathroom.
I understand, Mr. Hill, that that would be the easiest way, but since the law states that it needs to be a separate business, I think that there's some alternatives here. You have this listed as kitchen, and to the right here, what is this?
That's a media room.
A media room? So this is dark. Okay. I think that there's some other options. I think the whole point is it needs to be separated as a business. And I totally understand what you're saying, but I think that there needs to be some other options looked at. If you'd like to change the law, I think that you could petition for that. But as far as I'm concerned, I think, it has to stand as a separate business. I appreciate you coming forward and being forthright about it. That's wonderful. But, we still have to hold what the law says until it's changed. That's my...
I understand, but you don't feel that we would be meeting the spirit of the law by having a deadbolt on that door?
It's just...
I
It's
think
not what the law says.
I failed to tell you when my sister just passed with, she was a hairdresser for 45 years. So those products that you work with are toxic. And I hate to see them going into your home or a child or something. And I think that's why the law was written this way. Or that a child getting in here, going through this area from the garage or the house and getting into your store because the deadbolt accidentally got lost and getting into a product. I think this law was written to protect the public. I know you hairdressers put yourself in harm's way every day. I'm very much aware of that. But I think it's really, this law was really written to protect the public. And I think we have that responsibility here today to continue protecting the public. That's just my opinion on it.
Do you have any other comments, Mr. and Mrs. Hale? Any other board concerns or questions regarding this petition?
As much as I would like to help, I don't see how we can. I understand what you're saying, as Jeanette stated. And if I was in the situation, I would want a doorway there too. But the way the law's written, we can't do anything about it unless the law's changed.
At this time, I'd like to entertain a motion regarding the petition to appear for a variance to modify a cosmetological establishment.
I make a motion to deny the variance.
Are there any discussions regarding the motion? I'll entertain the vote. All those in favor?
Aye.
All those opposed? That motion carries and that variance has been denied. Mr. and Mrs. Hale, thank you. And I hope that you will follow through on amending or repealing that NAC 644.375.
Yes, I do.
Thank you. At this time, we're going to call our first appeal of citation, the clip joint, Eduardo Raul Cervantes, who came in a few minutes late. We had postponed that. Did I pronounce that name correctly?
Yeah, good enough.
Oh, Cervantes? Okay. If you'll step forward, please, and identify yourself to Mr. Nelson, and he'll swear you in.
You solemnly swear or affirm the testimony you're about to give before this board be the truth, the whole truth, and nothing but the truth.
All right. Ms. Bradley.
This is appeal of citation ES 115, and I would call Mr. Green as a witness. Mr. Green, I'm showing you what's been pre-marked as State's Exhibit 1. Do you recognize that?
Sarah, can you just clarify Mr. Green and Mr. One previously?
Yes, Mr. Green has been sworn previously. And did you also receive Exhibit 1, Mr. Cervantes?
Yes.
Okay. I'd ask that Exhibit 1 be admitted into evidence. Do you have any objection to that being admitted?
No.
So admitted.
Thank you. And Mr. Green, I'm also showing you what's been pre-marked as State Exhibit 2. Do you recognize that? And Mr. Cervantes, do you recognize that? Have you seen those documents?
Yes.
Okay. I'd ask that State's Exhibit 2 be admitted into evidence. Do you have any objection?
No.
Okay, thank you.
So admitted.
Mr. Green, can you please give us a summary of what the citation is all about?
Yes. I would like to preface by saying that the citation was written by an inspector who is no longer with the board. It appears that on April 21st, Ms. Steele entered the salon at 4514 East Charleston, observed a cat inside the salon. There was some explanation about whose cat it was and where it came from. And she issued a citation to the owner for a violation of NRS 644.472.
Okay. And so you're saying it was issued by another inspector, but
Correct.
you have access to the board's records and files.
Correct.
And do the two exhibits that we just submitted reflect the board's records for this?
They do.
Okay. So there was a cat in the establishment, and so did Ms. Steele issue a citation?
She did.
And what was that citation for?
The citation was for violating NRS 644472.
And was it a first offense?
It was a first offense.
Okay, and what was the dollar amount on that fine?
It was a $200 fine.
And was there a response given by Mr. Cervantes regarding the citation that Ms. Steele
I
reported?
believe, the response was that he wanted to appeal it.
Okay. I don't have any questions for Mr. Green.
Thank you. Did you have questions of Mr. Green
No.
or Ms. Bradley? Are there board members that have questions of Ms. Bradley or Mr. Green? Mr. Simmons, would you like to make a comment and state your position? Oh. Oh.
I don't have any more witnesses. So I would rest at this time, although I do reserve the right to call Mr. Green should I need to in a rebuttal.
Okay. Thank you for waiting.
I guess it's probably just a waste of time. I mean, there's the black and white.
It's not a waste of time. We're happy to have you.
The cat was in there. I mean, like you see on here, the cat was hurt. It was out in the parking lot. And I'm a cat owner. I have 3 cats at home and 2 dogs. So I took it to the vet. I think this was like a couple weeks before they actually came in and saw it there. But I took it to the vet and they cleaned up its wounds and gave me antibiotics and everything like that. And so I was taking care of it. I took it home at that point and took care of it because I had it in a crate and with a little cone on its head so it couldn't get to its wounds. And then after it healed up, I released it back outside in the back parking lot area and put up some signs, just hoping that the owners would find it. That I had the vet scan, see if it had a microchip on it, and basically I was just before all this, so the cat did live outside in the back alleyway, so that's why I released it back out there. There's like a clan of cats that live back there that I've fed for 10 years since I've had the shop there. So that's why I released it back out there. But it got attached to me during that time, and there's a window like right on my station's at the very front, and there's a window right there. So this cat would sit there, and while I was cutting hair, it would sit there and stare at me from outside and meowing and stuff like that. I didn't want to let it in. I really don't want a cat in the shop. But
It loves you.
it would figure out a way too when customers would walk in and out, they'd figure out a way he would like dart in and come in. So in time we started, I wouldn't even see it at the time, and I'd be walking into the back of the shop and it would just be sleeping in the corner of the shop there. I'd take it out, and in time I did kind of, everyone started liking it, being attached, and it was obviously had a home where it was used to people, because it's not like skittish or anything like that. It was really friendly. So I guess I'm guilty of not like putting it. I would let it come in and out as it wanted to at that time. Just think, look, I'm going to find it its home. I had pictures of it, trying to find it a home. And I guess I figured, okay, well, it might be easier. I kept asking customers, had all the stylists there asking customers when they would come in, okay, here it is. You can see how good of a cat it is. It's like, it's better to see a picture. Just trying to find it at home. Trying to find it at home at that point. And yeah, that's it. That's when I got busted.
And it sounds as if you realize that pets are not allowed.
Yeah, and at that point I really didn't know that I could get a fine or else I probably would just have kept it at home.
You would have not had it in your
I would have not had it in there because, And the only reason I even did allow it at that time was because it was such a good cat, and I'm not going to put an animal that's going to be unharmed to anybody, kids that come in or anything like that. I mean, some of my own cats that I have at home, I wouldn't bring in there just because they're very skittish, and I would be scared that someone's going to try to pet it and they're going to scratch him or something. But this cat was so calm and cool. I mean, it would just come in, and he was so good with kids that I didn't even. Yeah, I wasn't scared at it at all. Because obviously it's my responsibility. If it does hurt somebody, I'm the one that's going to get sued. But I wasn't worried about it one bit. And I didn't realize that this wasn't applying also until this happened. So, and at that time, I guess at that point in time, I was kind of emotional about it. And I was just like, man, I spent all this money on the bed already. This last thing I need is to get fined $200 now. So that was it. At that point, I was just thinking, okay, I'll kill it. And maybe if they can lower it or take it off since the first offense, that will help, but it was just worth a try, I guess.
Did you find a home for the cat?
No, it's living in my spare bedroom right now. I'm trying to, huh?
It's in your spare bedroom?
It's in my spare bedroom and spare bathroom.
Here's Brad.
Doesn't it?
I don't have any questions for Mr. Cervantes.
I have a question.
Yeah.
Would you ever be coming before us again for allowing an animal?
Would no. I mean, I love animals. So I mean, unless you guys caught me on the day that you guys caught me, like on the day that I found like a hurt animal outside, and I was just in the process of taking it to the vet. You guys caught me like red-handed like that. I mean, that would be it. I mean, but other than that, I'm not going to allow one to come in and stay and sleep or anything like that.
I have found out that I have what's called a designer dog. I have a little long-haired Chihuahua. If I come into your salon with my little dog, would you allow me in there?
I have before. I let people come in, with.
Do you realize what you're saying?
Yeah, no, I know. Because I wouldn't allow. I'm just being truthful. I wouldn't allow somebody, obviously, with a dog, like a pit bull or something, that walk in.
While we appreciate your very honest candor,
Yeah.
it's not just about the safety of the clients, it's also a sanitation issue.
Yeah, no, I understand.
So,
I know.
So the answer is no.
No, you can't allow any animals in your salon.
Yeah, no, I understand.
Unless they're American with Disabilities Act. That's the only
Right.
is a service dog, that's the only exception?
Yeah, no, I understand that.
But just because
I mean, I don't want an animal
going
going to the bathroom in my shop either, or doing anything that's going to harm anybody. So no, it was just a matter of, I just felt it was her, and I felt sorry for her, and that's kind of the situation that was up. I mean, I don't want one in there more than you guys want one in there too.
Are there any rebuttal witnesses?
I have no rebuttal witnesses.
Are there any final statements?
I would like to make a statement.
Please.
I have a salon in a hotel, and I had a lady come in with a rabbit and a little carry-on thing that she was just so in love with this rabbit. And even though she was like a $200 ticket, it broke my heart to have to tell her the rabbit had to go.
Yeah.
I mean,
No, I understand.
because she wasn't allowed to have an animal there.
Yeah.
Now, if you didn't know it, the law,
Yeah.
I understand, and I understand the kindness in your heart of trying to help this cat. But basically, the law is the
Yeah.
law. So
No,
if
that was
somebody
basically-
comes in,
that
one of
was-
your clients comes in with a dog, they're a little puppy, and they're just too cute, you just need to tell them, say, I'm so sorry, but that's breaking the law. If an inspector came in, it would be a fine for me.
Yeah, no, I know that now. I really never knew that it was, I mean, I figured, okay, you can't have any exotic pet or any animal that's going to be harmed. I mean, that's kind of a given. But a cat, like a little cat, I didn't think that was a problem, actually. But, well, I know now.
As a board member, I'd even be inclined, just based on the humor factor, to work with you with regards to the fine, as long as you understand that we don't ever want to see you in front of us again for the same thing. You can guarantee us that that's going to happen.
Yeah.
I mean, because it's clearly a sanitation, safety, and health issue.
And if the cat gets hurt, you need to take care of it outside of the house and take it outside of your office and take it to the vet, not take it in and care for it and then take it.
Oh, no, of course. No, I just meant like,
And
I
I'm
was carrying it.
inclined to agree with you that, and you understand, if we say you did a violation and you had to come back, it would be doubled. Is that not correct?
That is true.
If we waived his fine and if he came back, then it would be doubled and he came back.
What it would be, what I'm trying to say is, it
It's an older cat, so I don't think everyone's looking for kids.
Please, the board, I'd like to make a motion to approve the citation, but repeal the fine. So that, with the understanding that Mr. Cervantes comes before us again, he's going to be fined for a second offense. And hopefully it's humorous, but we'll be less enthused.
So there has been a motion to uphold the citation with a second. Are there any discussion? At this time, I'd like to entertain a vote. All those in favor of that motion? Aye.
Aye.
All those opposed? That motion passes.
So, just so that I'm clear, you upheld the citation and waived the fine.
Correct.
Correct.
Thank you, guys.
Be careful.
Just so you're aware, I will be sending you an order in the mail that tells you this, so you have it for your records, and so that you can remind yourself.
Who seconded that motion?
Thank you.
I propose a motion and Linda seconded.
Thank you.
At this time, did Touch Salon and Spa come in? Shy Safarji? Is that person here today? All right. Do I entertain a motion to uphold the citation because the respondent's not here?
Please, the board, I move to uphold the citation.
And is there a second?
Just a second. When you guys originally called it, you were going to continue it until after the other petitions were here. So I think it would
pardon
be
me.
better.
Did I not get through all of them? Oh, pardon me. So with Ms. Reynolds' recommendation, that Touch Salon and Spa will be held over one more, I guess, because there's a petition to appear for Roy Finish Group, requesting the board to approve a kiosk-style nail salon. Are you present? Oh, please come forward. And if you kindly identify yourself for Mr. Nelson and take that oath. So please state your names.
Both raise your right hand. You and each of you solemnly swear or affirm the testimony you're about to give before the board being true and full. For every member that's in the room, there's a jackhammer outside working, so you'll have to speak up so everybody can hear. Mr. President, staff report has been prepared for the board members. These folks are here to get an approval of a kiosk type of setup in a center of a mall configuration instead of an enclosed room where you lock the door and you have a wall that says your territory is this address. In the center of the mall, they put kiosk type setups. Staff took Mr. Finish to task on every issue that we could find in the requirements and have found that he's been able to meet the standards as defined as well as we can figure out. That everything that we've asked him to do, he's either shown that he can do it, because they can buy equipment that can meet that standard. And the biggest standards that we were having difficulty with is it has to be within 100 feet of a restroom. So that's a location problem. And the second issue is hot and cold running water. And in your packet, they provided documentation from companies that can provide that equipment. It is a uniqueness for our board. We've never approved one like this before, but it appears from staff's analysis that they've met every requirement that we believe sets in the law.
Mr. Chernow, what distinguishes this application from a mobile establishment?
It doesn't have wheels. That's about it. Everything else is the same.
But it's my understanding that there's either a fixed location or a non-fixed location. So how is this different than either one of those?
This would be fixed if they had a contract with the mall, and the mall said that we will place them within 100 foot of a restroom facility. And we have one already built and one being built at the airport that fits into a similar pattern, except they have enclosed walls. That's the only difference. So Mr. finished was challenged on how do we get hot, cold running water. And there's been the information and the equipment they would be willing to buy and get approved has been provided to you so you can see it. Ms. Booth, who has had a number of conversations with me, has asked a number of questions regarding the equipment, how we see there would be working, and that sort of thing. So our recommendation is that it does meet all the requirements that we can see, except for the walls going from the floor to the ceiling and a lockable door. It is not truly a kiosk. It's really a floor plan that's in the center of a mall that's designated for nail technology and the services they provide. And they have all the equipment that we would normally require.
It's kind of like you guys could put it in a mall or anywhere. I mean, it sounds like you guys could put it down at like an event. Like if there was a nice event in town, you guys could put it down there.
As long as it's closed mall.
Kind of portable.
Yeah.
Yeah, it's like you can move it around a little bit.
And
Is that right? I mean, could you?
Again, 100 feet of that.
Yeah, I mean, just one question. You communicated copies of the thing that we submitted. I want to ask you if you have the picture of the kiosk, if you can look at it for a second.
Yeah. It looks like it could go anywhere, like the rid of cook-off.
Exactly. It's a new idea that comes from Europe, Israel, Russia, Hong Kong. They're working. It's already established companies working like that by the franchise. The only problem that we saw that it's the requirement of the sink that is a little bit problematic. We sink in the middle of the mall with connected to the wall.
Leader, is not truly easy to move. It's established heavy pieces of equipment, furnishings, walls, and the items that they're purchasing are not on wheels and things like that. But it's got all the same attributes of a mobile establishment, except that it would be a designated area within a mall, and if they were, as long as they were within the 100-foot requirement of a restroom facility, they'd be okay. If they moved it outside of that, they knew they would be in violation. The biggest concern is sanitation, hot and cold running water, and protecting the purity of the water and that sort of thing. And they have equipment that does that. So the issue is it's not really too mobile. If you look at the pieces, they're quite heavy.
But it doesn't just have to be in a mall, does it? I mean, it can be more than just a mall.
In general, the idea is to get a high traffic mall, as I saw and as I did a research for it. On the strip, there is a lot of spa beds. All of them offer very expensive treatments. The idea behind it is express medical, something like 15 minutes and a little treatment just to feel a little better, feel a little better, do a little better, and then you have to go to the party or to...
Yeah, it could be, but we control whether they're licensed or not based on the sanitation issues, the safety of the public, and those kind of things. I don't think it's a situation where we're granting a variance. They're meeting the standards that we would approve under normal conditions. But if you put it in an event site, we probably would not approve it because there's no guarantee of being able to maintain sanitation conditions, those kinds of things.
So are we looking at both the structure, the kiosk, as well as the location, the mall? Like we're approving two things then. We're approving like a shell, like lean-to, or we're approving it in a mall.
Well, it's like a floor plan.
Okay. We're approving a floor.
When we get a lease, you have a particular address on the lease and square footage, and it doesn't, because you don't like it today, tomorrow you just move down a block in the same block and move the store without our approval. We have to still go through all the same steps with the first approval. This would be the same kind of thing. If we approved it, the site we'd be approving is the specific location, the specific conditions around it to be sure that it's safe and sanitary, and they're within the requirements of the restroom facilities, and the ability to get fresh water dispose of wastewater and that sort of thing. So it's more than just, when we approve any establishment, we approve the site too.
I thought we're here that you said the site was okay, that the variance, that we're here to approve a variance for a sink.
It's really not a variance, it's just that in a mobile establishment, which is clearly written for something with wheels, requires certain kinds of water supplies and the kind of things that protect sanitation and health of the users. That's exactly what we looked at here, is the issue of water supply, hot and cold water, running water, purity of the water, close proximity for the water to be changed out because it's near facilities, and the restroom facilities available to customers. So it's not really a variance, it's just being approved one.
Mr. Hoffman.
Are you looking at doing only manicures? Are you talking about doing anything else? Are you looking at doing
To do an
pedicures?
express treatment that is not required any medical treatment or penetrating treatment, something that is very fast on the go, something that's just nail
So you're looking at doing
for the
just
face, but not something more than that or more complicated medical or something like that.
So you're going to do nails?
Yes,
Are you going to do
basic.
pedicures?
Yes, basic.
Are you going to do any facial things?
Because I'm not in the industry. I'm just a businessman that's trying to develop new ideas.
Yes.
So,
Mr. President, I didn't mean to interrupt you, but the issue is that they couldn't use a pedicure spa operation there because it's not the right tone or whatever. It would be nails at this point. If they were going to do facials, they'd have to be licensed for, as a cosmetologist has, not just a nail technologist.
So now we're just looking at manicuring.
And also
At
skin
this point,
treatments.
that's all we've been able to glean from them, that all that they're doing is manicuring.
And you're going to sell makeup, correct? Are you selling makeup and
Like
products?
lotion for the face and nails. That's it, the basic idea.
And Mr. Jimno,
No
you're,
medical or something.
sorry.
It's a skincare express.
If it's skincare, they'll have to have a person qualified on the site use any
So
kind
a
of
licensed
skincare.
aesthetics or cosmetology.
Again, the staff would have to approve whether that fits the standards of sanitation requirements, equipment requirements for skincare. If you're just doing nails, it's a lot easier.
So all the information that you have given us is with regards to nails solely?
At this,
Okay. And any additional approval of skin would have to go through you and be shown to us?
and the inspection staff would be ones that
Involved.
approve that. The issue is the concept of having it outside of a four-walled room is what the board
Right,
has
it's an
never
open
approved.
air kiosk at the mall.
That's correct. The other requirements all stand in order. They still are.
So they've met everything that's required of them
At this
to be
point.
licensed.
Ms. Curtis, do you have any other comments about it?
Yes. The main things that you would be doing a variance on is that there are no walls and that you're going to, the regulation requires permanent plumbing, but they're asking for mobile plumbing. Could you tell me how much water would be in each of your tanks?
The standard for the equipment that we search is 5 or 6 gallons.
5 or
Of
6
fresh,
gallons.
of fresh.
It
The waste
varies a
gonna
little bit
be-
from the information that they have. So it would be 5 or 6 gallons.
Yes.
Okay. The only situation you'd run into if they're going to be doing, sir,
The materials they provided to the agency showed a greater quantity of water than that. They showed 20, I think 50 gallons.
He said
25
5.
gallon tank.
As the research, everything is a custom made. Even if I want a bigger container, everything is possible. It's under for you to decide if you
You're
want
saying-
10 gallons.
you're saying a large amount of water is possible.
Yes, a little bit larger, it's definitely possible. Everything is possible, basically. If
Fair enough, you can.
Right, so you have to, if we
Okay.
say that we require a specific amount of water, then you'll design
we
something
can make it,
that
we can make it work.
I think I'm hearing that you also want to do lotions and things for a face and that kind of stuff. Is that what I'm hearing?
Basically,
Okay.
that's
You need to take in consideration that in the malls, you have retailers that can do those things and apply things. You got to differentiate if they're going to be doing that in a licensed establishment, if that is the case, because that would be breaking some of the laws and putting it into a retail situation, because they do that and we have no jurisdiction over that in the mall.
Just like at the MAC counter.
The retailers, yeah, with lotions and creams and things like that. So you would be making a...
But if you're licensed as a manicuring establishment, that would not be allowed unless it was specifically designed to follow the regulations required for estheticians or a demonstrator's license. So you're putting yourself in a situation where you can't just do everything and apply for a manicuring booth.
No, the idea is to work with you guys. It's
Right.
not to work, to get approved and to do whatever we want. Everything, that's why we're doing step by step to follow the rules, and we want to establish a company and kiosk that's going to work, not just one. Hopefully we're going to get, you're going to see them, like, I believe after this is going to approve, we're going to see a lot of them on the...
I wanted to bring a question up or something. I actually called the company and talked to one of these companies. When you have 25 gallons of water, sometimes the people changing them, they have to be changed out, these waters. So we may not want to say that you have to have 25-gallon tank, that maybe you have 5-gallon, or
Less fresh and more waste.
yeah, because somebody's going to be lifting them, so we won't want to put 25 gallons, I think, on somebody trying to lift a nail tech, trying to put in and out.
And there may have been an error on my part in saying 50 gallons, but I think when you look into the material, it says 5-gallon
Right.
freshwater tanks with a 6-gallon wastewater tank. The issue is, that's one of the issues that the board would say, it doesn't meet our standards, or it does meet our standards if these things are done.
Where do you dump that wastewater?
Of course, in the mall.
Where?
There is a specific place when they dump the mall, they dump the waste.
Like a
when
drain?
they wash, yeah, they have like a hole in the wall, in the floor or something like
So
that.
you'll
Specific
have
for
someone
something.
there doing that. You're not going to just tell some little manicure, so, okay, haul that
No,
water out.
Some of it, of course, everybody gonna be in license, and I'm gonna tell them, okay, now it's your job to go and lift 5 or 6 gallons of water and go all the way over there and trash it or something like that. Of course, it's gonna be organized and everything's gonna be fixed right.
I had a couple things that I wanted to bring up. Is this the time to bring it up? No, not quite.
Mr. General, I just wanted to take another quick look at NAC 644-600, which is the mobile cosmetological establishments. And item number 2 is mobile cosmetological establishment means a self-contained, self-supporting, enclosed mobile unit where one or more persons are engaged in the practice of cosmetology. But I don't see wheels.
Mobile means that you can move it, and this, you're right, the only mobiles that have ever been approved by the state are on wheels.
Right.
There's only been a couple. But the issue here is twofold. A mobile establishment I believe, has to have 50 gallons.
Pardon?
Mobile establishment has to have 50 gallons of fresh water.
No, 6
Or 100.
gallons. 6
100.
gallons. Right.
Not in the code.
A supply of
It's a
water,
100
it must have 100 gallons.
100 gallons.
100 gallons.
644, 645. And that's for a mobile establishment, must have 100 gallons of self-contained water in drained black holding tanks, indicating levels. And then an establishment must have tanks which provide hot water continually and on demand with a combined capacity of at least 6 gallons.
That's the issue right there.
So, to me, the mobile establishment is 100 gallons, but an establishment has to have continual hot water of at least 6 gallons.
Hot running water, period.
I guess I'm still kind of stuck on how a kiosk is different from a mobile establishment.
I think it's more like this.
This is more of a fixed.
It's a self-contained fix, the stuff.
It's a self-contained fix. The real issue for the board is their amount of water they have available is very limited. They can produce equipment that has a separated, a portable freshwater tank and a wastewater capture tank. That can be done, but it's not 100 gallons. And they have no permanent piping that comes to us. Those are the issues. And the only other issue is it's in a mall setting, in the center of the mall, not in one of the individual addresses. So those are the two major, we've never approved one of these before. And they're trying to show us that they have equipment if it's acceptable to the board. The issue isn't 5 gallons of water sufficient to do proper hand washing? I don't believe it would be enough if they were doing facials and things like that.
Now, and also for a mobile establishment, even though there's some confusion whether this applies as a mobile, it does say that they need a written approval granting permission to use a dumping station. So are we also going to be asking the mall to have some type of approval for them to... Hard to know, but I mean...
A dump station is totally different than what they'll use at the mall.
They're going to use that, right?
Is it just the bathroom?
It's just like, not
It's
exactly,
where you
it's
would
just
fill
the
it.
way the
Oh.
matron.
Wait a minute. One at a time. So you just use the bathroom to dump it?
Is exactly, it has the maintenance, wash the floor, they have a big bucket with water. I believe it's the same
Mop
thing.
bucket
Everything
filling
is something.
station with a floor drain. Basically.
There was one other thing when I talked to the one company, the tanks that they use, and that's why I've written up some of these things, the tanks that they use aren't white, they're just glitter color. That's why my recommendation would be that they would be clearly marked, a dirty tank, clean water, so that, and the lines also coming down are the same color on these little wash stations, so that those lines would be clearly marked too. That would be my recommendation, yes.
Yes, it's definitely something that's extremely important, and it's totally different containers with different sizes, with different mechanism, how to connect them with different hoses. I don't believe it's something that you need to be very mixed with force or very want to do it differently as the manufacturer did, because of course it's something that's extremely important and you don't want to mix stuff. And it's also with a big sticker. And of course, we're going to make sure that it's marked differently. It's a different mechanism of the way you connect the hoses. I don't see, I don't think it's going to be an issue or something.
And I think that's what I was kind of, what I had drafted up here is kind of to, I like the idea, I think it's a great idea, but just to have, just not to say, here, you can go do it. Yes, there would be some rules, like how often you clean the tank out, and that it was marked clearly, and so anybody that changed the water out or something, they knew what the gray water was versus the white water, and that you did clean those lines out, because talking to the different companies, you do have to sanitize those tanks periodically, and then also to have it marked down that the water's not human consumption, so that somebody doesn't just run along and grab a glass of water, or somebody that is the public walks over and gets themselves a glass of water or something, so that it would be clearly marked. So I just had those few things that I'm absolutely for this. I think it's a great thing for people to have a business and survive and go forward, but I think we just needed to add a few items on with that variance that would allow you to put the stipulation. And I think one of the stipulations that I'd like to see is that the inspector of the Cosmetology Board also inspect your log of when you sanitize those containers back that
Some sort of system that they would have to be required to keep. I think that's a good, because 5 gallons is obviously not that, especially for like 100 gallons. So I think a law or something that we could implement that would be a requirement for this type of fixed.
Mr. Jimna, they also have a pedicure bowl where you put a liner in the bowl, and that's what you actually remove, is that liner. So the pedicure basin never really is contaminated by the client. It's the liner that's contaminated. So I mean, earlier I think I heard you say that maybe pedicures would still be kind of something that you determine, but if they were using that type of liner system, then it sounds to me like they'd also be entitled to do a pedicure.
Your issue then would be how much wastewater they would have and how they transferred the kind of plumbing they would need to do all of that. I really think from an engineering standpoint, it's very difficult for a pedicure operation. I can see a nail technician operation because you don't need the water other than washing your hands. I do have some concerns regarding the wastewater that Ms. Booth, board member Booth, has brought to the table. And I do have some concerns about aesthetics if it isn't fitting all the requirements of aesthetics. Nail technology is slightly different than aesthetics, as you're well aware of in your profession. So those are the concerns I have. If they think they're seeing a cosmetology establishment, a full-service one, we have a problem with it. But if it's nail technology only, it's a little more controllable. And the second part is it doesn't totally comply with the current regulations and statutes as written. So you'd have to say, if we want to do this, we're doing it in the interest of not inhibiting new businesses and the interest of justice or equity to considering the circumstances, specific circumstances.
Can I add to that? Just so we're clear, what you're being asked today, as I understand it, is to allow this pursuant to NAC 644-330, which says permanent plumbing. So the variance that you're being asked about today has to do with the fact that by the normal sense of what we mean by permanent plumbing, it's not going to be permanent. It's going to be these mobile type plumbing. I mean, I suppose it'd be permanent to that establishment, but not permanent in the normal sense of the word. And so what the board's being asked to review is whether or not you think that you'd like to approve that. And as Mr. Dimno said, I'd like, if you do choose to approve it, that you make a note pursuant to NAC 644040, which says that you'll permit deviation if you find there's good cause for the deviation and the ends of justice so require. So in other words, this is a unique idea. It's something they haven't heard before. When we think of permanent plumbing, this isn't really what we think, but it would be permanent to this establishment. So if the board believes that's true, I'd like you just to say that's why you're making the deviation. And I think for today, that's what you're looking at. Going forward, it sounds like there might be other things that will come up as this progresses.
So, just real quick, Mr. Kuno, my only question then is, if it is a self-contained fixed establishment, are there recommendations to the board for how much water we should require them to have, both clean and waste?
I think the company has, it appears 5 gallons. I think I put 50 in the report. 5-gallon freshwater tanks. The board can say, make a requirement that you have at least 2 or 3 of those containers available so they can be easily transferred out, and that you have sufficient wastewater capture tanks to capture that water.
So kind of backup tanks, backup.
Well,
That's exactly what I want to have. All kiosks built up with the hidden space. Definitely no less than 1 or 2, no doubt. For the clean and for the waste as well.
I don't think the waste would be dumped immediately.
Exactly.
At
the end of the day.
Should we put that number?
Well, yeah, I was going to say, I think I meant it to the questions that you have in that situation. I feel that it's something we can improve. I think it's to foster business. It's a nice idea.
So can I make a motion?
I just wanted to double check on the ventilation if you decide that you're going to be doing acrylic nails. Will you do like press-on nails or gels or acrylic?
The general idea is to provide the customer what he wants. The idea is to make something that is very convenient. You don't need to schedule an appointment to make sure that the kids is in the right place and to go when you're in a vacation, basically. Of course, if we can make the acrylic and the gel, it will be perfect. If not, we can work something, and of course, with your approval, it's not something that we...
Maybe a note on that. If you
Yeah.
go forward with
And
some
eventually-
sort of
But I don't think we're
downward
talking
regulation.
about shells right now.
Well, if they're going to be moving forward with what the client wants, the clients want shells. They want shells for their clothes.
Let me ask this question. Have we posted it to where we can make a decision on that today?
No, but you're taking notes on what the law would be requirements. Yeah.
I'm talking about the water tank only.
All right. Go ahead.
And another question about the ventilation system. The more have ventilation system, the requirement that it's going to be 100 feet from a restroom is something that definitely we can work with the mall to get the location. But before doing this step, we can go forward with the mall to get those.
Mr. Jim.
Not being an expert in the ventilation of acrylic chemicals, I'm a little bit concerned about chemicals. If we find if the board should decide to approve this, we should be flexible enough for if we do not find it acceptable when it's actually in progress, that we have some ability to change that versus if once it's approved, we have a problem. In a case like this, there's no way we can demand proper ventilation because the center courts, our main air transfer system is only our, there's no tube that goes up to the roof.
So just as a friendly reminder for the board members that if you are planning to make the motion shouldn't use the word variance. It's a deviation according to 644.030. So in the event that you are making that motion, the wording is deviation.
Okay, I would like to make a deviation
Or a motion.
or a motion. I'd like to make a motion for a deviation, sorry, of 64440 and to approve the portable sink with the following recommendations attached: wastewater tank and wastewater lines to be clearly marked in permanent ink or labeled wastewater or wastewater line. Freshwater tank and freshwater line to be clearly marked in permanent ink or labeled freshwater or freshwater line. Tanks and plumbing lines cleaned monthly per professional standards, and the salon to maintain a log that can be reviewed by the cosmetology inspector. Sink with sign that states not for human consumption or do not drink, for hand washing only. The kiosk to also have 50 gallons of fresh water on hand, and that the wastewater be dumped immediately, that there's no standing wastewater.
I'll second that motion.
Are there any discussions regarding this?
Did you say 50?
What's that?
Did you say 50?
I think 50, do you feel that's too much?
No, I don't know. I just want to be clear.
Yes, sir?
I'm not an expert, but I think 50 is very big amount. The people are going to put the dining container one next to each other. It's going to take all the space, even inside the kiosk.
So what do you think would be, for a day's worth of use, what do you think we should have?
I'm not an expert, but I was thinking that, of course, the one that isn't used and another one or two as backup extra.
So
About 15.
Yeah, so two backup would make 15 gallons of fresh water.
What do you think, Linda? Well, as a manicurist, you're not going to use that much water per person. But when you get into pedicures, you get started doing that. Now you're talking several gallons of water per pedicure.
But I think excuse me, but I think Mr. Jimno was saying that with each level of service activity, that's an administrative decision.
Well, but I'm also thinking if they're spending the money to do this, and you're looking at it, you may be looking towards what you're going to be doing in the future as far as the water goes, not just what you're starting out with, and then 6 months later, you come back to us and we tell you, okay, now you have to have 50 gallons of water. Does that make
Mr. President, I think Mr. Ziegler brings up an excellent point. As I indicated, I was not real receptive to doing pedicures because it usually takes a lot of water. It takes anywhere from 5, 10 gallons for each person. If you look at a pedicure operation, I'm not familiar with any of the ones where they just use a liner, but you still got 3 or 4 gallons of water in there. Then you got to dispose of it, and it's not going to be an easy thing. I would not recommend personally, from an executive, from an administrative standpoint, that you authorize a full service pedicures and esthetician work. If it's a nail technology spot, that's one thing, but I would not recommend the other. And
My motion is only for the state.
to consider the issue mainly on that is water, disposable water for washing of hands. That's a different process. I mean, you use it for washing hair, doing pedicures, and facials, and all that stuff. Where you may have a lot of old lotions you have to remove. It takes a lot of water. So the issue is, does the board want to allow nail technology operation versus a more service-oriented, multi-service-oriented site? At this point, I don't know if we have the technology in place from an administrative standpoint to enforce any of that, other than the nail technology.
So with the motion on the table, the motion on the table.
I wanted to amend my motion
Okay.
from 50 gallons of fresh water down to 20 gallons of fresh water.
And once again, the motion on the table with the second is merely approving the sink for the kiosk-style nail station. We have yet to approve the kiosk-style nail station. Just so we're real clear. So is there any more discussion on the sink?
Whoever seconded me,
I would like to do that. Second, to change it to 20 and 20.
Is there other discussion? And I'll entertain the vote for the motion to approve this kiosk-style sink. All those in favor? All those opposed? That motion carries. Now that the sink, or the plumbing, if you will, has been identified as acceptable to the board for this type of establishment, the petitioners have asked that the board approve a kiosk-style nail salon for location in a mall environment. We did hear from Mr. Jimno that both the floor plan and the specific location are what the board approves. So I would like to entertain either a discussion or a motion to approve or deny the petitioner's request.
I don't find anything on that in my, that's my question, I think. I don't find anything on that in here, Mr. Gino, or... Okay, so we're going for a kiosk-style nail salon. Okay,
Right.
I'm sorry.
So again, I'll entertain that motion to approve or deny the request.
I'll make a motion to approve the request to have a nail station located in this mall environment.
I'll second the motion.
And is there a discussion?
I'd like to know where it's going to be.
So long as it meets the statutes that are required by the state board with regards to being within 100 feet of the path, all the various other requirements.
Well, it would not be approved without administrative approval, if I'm correct. I mean, once we approve the kiosk-style nail salon for location in a mall environment, now administratively, there's going to be some things that they're going to have to follow, like some type of system for recording these wastewater dump meetings and checking in on that. So those all will happen administratively, if I'm understanding this correct.
Yeah, the inspectors will have to be able to track certain information, to be able to watch to see if they in fact drain the water out when they're supposed to, and those kinds of issues. The issue for us is that it's not a full law operation.
Right.
And there was no permanent plumbing. Those are the two main issues.
And now we've approved that plumbing source.
And also now the lack of walls.
So would there be some notes added to this?
Well, that will happen administratively. So administratively, they still are going to have some type of obligation back to Mr. Jimno to be able to ensure that you're following some type of protocol for us, and those would be established for you. I just do want to make it very clear that I do not see a distinction between a kiosk-style nail salon and a mobile establishment. Despite some of the objections of that, I'm not very clear on that. I believe that there is either a fixed location or there's a mobile location. Mr. Chairman?
I would like the board to indicate as a condition of the approval of this concept that reporting procedures be established by staff so we can track certain information, be sure they are in fact compliant, and that if it's, in our opinion, not appropriately being done, we report, bring it back before the board.
So would you like to amend your motion to reflect Mr. Jimno's comments?
I will amend my motion to reflect that staff will come up with these different rules that you'll have to follow, and that if you don't comply, then you'll come back before us.
And would the second amend it to that?
And the reason Mr. Jimno is wanting to make that clarification is that normally those aren't things that you require of people. And so we're wanting to make it be clear that you're approving this, but in approving it, you're going to ask for a couple additional things that you don't normally ask of others. And so that's something that we'll want to have it be in writing with you so that you know what that is, what you're going to be expected to do. So, for example, the log of, to keep track of how often the water's changed and that kind of stuff. So,
And sanitize too. I think that was one of the important things that I found, and some things that's happened in the hotel with the Legionnaires and whatnot. So it's important that those lines are sanitized. So, and I think we're kind of breaking ground here because you're the first, but I'm sure there'll be others following. So we'll have to work to go.
We need to be fast.
You have to be as a perfect example.
Yes.
Or it won't happen again, and it won't
make
happen
it right
either.
Ms. Curtis?
Okay, I'd like to be clear on exactly what the board is possibly approving at this point. Are you approving manicures only?
A
With no-
kiosk-style nail station
And with the plumbing? With the
for
plumbing.
location in a mall environment.
Yes.
Subject to some guidelines or some protocols that administration will establish and that they will submit to them, and they'll be in compliance with.
And also, there's been discussion on whether they would be doing gels or nails
Not at this
or
time.
acrylics or manicures or pedicures.
Well, just not at this time.
All we've established at this point is that we're approving it going forward.
Okay, so that is the clarity that needs to be.
So now we're going on to the mail.
That's not what we're here to establish. We're just here to establish that we're approving that they start from this point, meet with the administrative, and then the next time they need an approval, they're going to come before us again, and we're going to make a determination at that time.
And so in the event that this kiosk-style nail salon wants to have a different location, well, then they'll make that, they'll approach the board for a new location.
So aren't you saying they can go forward with it?
We are. Well, we haven't voted, but that's what the motion is
Okay,
on the
but
table.
then let me ask this question that I'm hearing here. If you're saying they can go forward with nails only, we're talking about nails only, no pedicures. Gels are certainly one that you want to be putting on. Why are we telling them what they can do and what they can't do if they're doing a nails?
I don't think we are telling them that.
I think Mr. Hoffman misunderstood what I said. What I indicated is that if the board, what I meant to indicate is if the board really doesn't want ones with high volume of chemical release, like the one that you talked about, then we should be clear about that. What I was talking about, Mr. Hoffman, is that if we find that the conditions we've placed on it are not working, they're not safe, or we believe that they're unsafe, we would have the board's instruction to bring it back for further review, and that it's not a permanent gift of approval that's from now on forever approved. If you're still holding strings, that it's got to work.
It's going to be
Staff is really going to has to make that decision whether it's working or not. It's still safe, and if it's not, you have the right, or at least instructions to bring it back to you for further discussion. That puts a risk on the investors to recognize that if it doesn't work, they're going to be out some money because we're not going to accept it if it's not healthy and safe and sanitary.
And you understand that before we take a vote?
Yes.
Can I ask you another question? Does the health department, who determines if it's healthy or not? Does the health department come in and determine that? Do they have to be licensed?
Well, we do, but we can call the health department.
Okay, so there would be somebody that was an authority on that type of thing, would be able to come in and monitor fumes and stuff like that.
There's an example of if the wastewater is not changed out properly, or we find that the tubes are not properly maintained and placed at a frequency that would be considered appropriate, those would be sanitary issues. So those, we would ask them to bring it back to you and say that it's not working the way it's designed.
Thank you. In the interest of these gentlemen getting their business moving forward, though, because we have to hold on and then wait for Kemba for the board again. We need to bring up a special session, or they're going to have to wait 4 months or 3 months. I don't think that's
not
right. Yeah. So I just want to be clear that they can move forward. And where are you guys at right now? Let me ask you, how close are you to becoming finished with your project?
We have the proposal for all the big casinos and the shopping center malls, and we don't want to go with them if we don't stick with them.
Right.
Get stuff
So
done.
it's a couple months or?
Hopefully, everything in the kiosk is custom made and everything will fit your requirements and the mall requirements in order for us to work as right. I believe something like that will take at least 3, 4, even maybe 5 months to build up that kind of thing, to know what everybody wants and to build it safely and under the requirements.
If we can make sure that you have communication with the executive director and the board, we can follow up on that so we can expedite that for you, so we can get you moving, so you don't have to be constantly coming back to find out new rules and regulations for you, which would make it hamper. I think that's really important in the interest of them being going.
This is new ground we're cutting, and it's going to be difficult decisions because it's not conforming to the historical approach that the board has taken for many years. It is consistent with the governor's movement to allow more creative ways to produce jobs and things. But sanitation is the driving force, so that's what we're going to be focused on. The staff's going to have to sit down and argue a lot of these issues out to see what's acceptable and what's not, what would work.
And we'll be able to put these down in specific order, get them back to these gentlemen, and then have some sort of replies that we're ready next time to just go ahead and give them.
We're not asking to come back again. We're asking that we're making the decision today to allow us to move forward with the conditions that I asked to be put to it that allows us that if those conditions are not being met, we can then schedule it back.
And I understand what you're saying there, but there's still, if I was opening up this kiosk, I would want to be able to do gels because it's definitely much more lucrative. So the filters and that, what would be required on them?
I don't
It's
think
gonna be an
we
additional-
prevented that. We're not
Right.
preventing that.
But it's all, it's not, I think it is prevented.
The board can direct staff to determine appropriate, exhaust is mentioned in here, and and the requirement for exhaust is just that it be, it's NAC 644315. It says each cosmetological establishment and each room or residence uses an establishment must have a system for exhaust acceptable to the board. So if the board wants, the board can direct staff to determine what the appropriate ventilation would be, to do these services. And I think that probably you've given some leeway in that area already because it's not specified.
As long as they have leeway and they're not being only regulated to just do manicures.
No.
And I think that in a mall setting or a casino setting, if the fumes are running off clients, they're going to be on top of these people probably well before us. So, and I know that they have a little station, so I think that anybody that has a business, especially a mall, is going to want to be entered properly and not have stop clients from going in that area.
Yes, that's true.
Also, your stations can have a vent in them, you can have a ventilation system in them. And just as a suggestion, don't look for the cheapest products to buy. Look for the good products. You won't have the odors. You won't have people returning. You will have a much better business, and you won't have a lot of return people. So you want to use good products. You want to make sure what you're using is good.
So just to summarize, we have a motion on the table to approve the kiosk-style nail salon for location in a mall environment. We gave 6 recommendations, and there will be other policies or protocols that will be forthcoming. It does not prevent you from doing the gel nails or anything that is applied to the nail, contingent upon administrative determination that they'll work with you. Would that motion has been seconded?
Well, we already voted on this one.
No, this is
No, we have not voted.
Online?
We voted on yours. This is the second
This
one on the
is
nail
the second-
kiosk.
This is on the kiosk.
Yeah,
With the recommendation.
for the same question. Are there any other questions? I'd like to ask for that vote. All those in favor, please say aye.
Aye.
All those opposed, nay. Motion carries. Congratulations.
It's the crowds.
I'd like to buy a pair.
Thank you. We're going to do one more, and then I think we're going to break for lunch. So I thought that in the interest of some of the schools who are attending, I'd like to please move number 13. Oh, wait, you're right. I have that one more petition.
Number 7.
Thank you. Yeah.
Touch salon and spa.
So I've been reminded by Ms. Reynolds that Touch Salon and Spa, are they present? Shay Safarty, is she present or he present?
He's not here.
Okay, I'd like to entertain a motion that in the absence of the respondent, that we accept a motion. Oh, Ms. Bradley.
If I could, I'd like to have some testimony from Ms. Blasco, just to put on the record that Touch Salon was notified of the citation today.
Ms. Blasco, can you attest to that?
Well, I'd like to ask her a couple questions, if I
please.
could. Can you swear or raise please, here?
You solemnly swear or affirm the testimony you're about to give before the court, be the truth, the whole truth, and nothing but the truth.
I do.
Ms. Blasco, would you please state your name and spell your last name for the record?
Deborah Blasco, Blasco,
And who is your employer?
Nevada State Board of Cosmetology.
And as a part of your duties as an employee for the Nevada State Board of Cosmetology, do you send notices out for the meetings?
Yes, I do.
And I'm showing you what's been pre-marked as State's Exhibit 1. Do you recognize that?
Yes, I do.
And what is that?
It is my notice to appear for Touch Salon and Spa.
And did you send that notice?
I sent it via certified mail on January 12th and also through regular U.S. mail.
Okay. And was this returned to you?
I have not gotten anything back on it.
Okay. So as far as you know, this notice was received.
Yes.
I would ask that the notice be admitted as State's Exhibit 1. I believe the board has a copy.
So admitted.
And based on Ms. Blasco's testimony, I would ask that the board find that the licensee was given notice of the citation appeal today, and that the board then uphold the citation in the respondent's.
I make a motion to uphold the citation. Or the citation was, the proper notice was
Yes.
served to the respondent.
Yes, I would actually ask it to be 2 things. So your motion can be that the citation, that the notice was given, proper legal notice was given of today's citation appeal, and that in the person's absence, the citation be upheld. That's what I would
So my motion is a two-parter, and the first part is that the proper notification was given and the citation be upheld.
Is there any discussion on that motion or the second? I'd like to entertain a vote to either approve or deny that motion. All those in favor? All those opposed? That motion has been approved. That appeal has been denied. Again, in the interest of the schools that are attending today's meeting, item number 13 will conclude our morning session. And so we're moving the discussion regarding the tuition reimbursement policy. That's where we're at right now. Mr. Jimmer, would you maybe like to start or lead on this tuition reimbursement policy? There are some schools.
You want to hold that over? I thought we were going to.
Well,
No, that's not for the schools, that's for our
Employee.
One reason or another, I asked the school members.
surety bond.
The surety bond for the school? Is that what I made a mistake there? Pardon me. So another mistake. Pardon me. So I'm going to move item number 14 rather than 13. Is the discussion regarding the regulation implementing surety bond level and an alternative to maintaining a surety bond pursuant to SB 193. That's relevant to those school members who are present. And Mr. Jim, I'll start with you, please.
Background of this is SB 193, which was legislation we sponsored with the help of Dr. Hardy, Senator Hardy, regarding a number of issues. And one of those issues was the repeal of the surety bond that was in place prior to the legislative session. The legislature did in fact repeal the existing surety bond requirement law that required $400,000 for a new school after July 1st or thereafter for any school being established within the state of Nevada. The schools prior to that date were only required a $10,000 surety bond. When the law was repealed, the board requested a total repeal of the law, but there was a number of players in both from schools and the legislature that opted to have some kind of surety bond and not completely eliminate it. And secondly, have an alternative method for them to be allowed so they didn't have to have a surety bond if they choose an alternative method. After a number of 2 hearings and some formal meetings that were posted, we took a lot of input from a number of people. The schools had separate meetings where they inputted their opinion of what needed to be done, and we held workshops in both northern and southern Nevada and took input. And then I've interviewed both the past president, immediately past president, and the new president, and asked for their views as to what we should be now putting into regulation. Under SB 193, the legislature directed the board to be responsible to put in a level of surety bond through regulation rather than the NRS system. And secondly, to final design the alternative method, and in lieu of a surety bond, you could use the alternative method. In the materials that you were provided, the recommendation by staff is a $50,000 surety bond for all schools if they choose to use the surety bond method, and an alternative payment method for those non-federally funded students who the formula would be parallel to the U.S. Department of Education. I've consulted with them, I've read their payment regulations, and basically that requires, ours is not to be, didn't have to be exact, but something similar. And the recommendation is 25%. The schools can take a non-federally funded student and charge them, invoice them for 25% of the program, and then they cannot invoice a second part of the program until they complete at least 50% of the previous or the current portion. So when you're at 0%, you can invoice for the first 25%. When you reach the 50% of that first portion, you can now invoice for the second portion, and on through the end. So that's the recommendation. What this meeting's about is the board needs to give staff approval now to put that into the legal wording with LCB and begin the process of hosting the public hearings and the adoption hearing, and then submittal to the LCB for consideration by the Legislative Commission. So that's where we are in this. staff is recommending $50,000 across the board, and the schools have the option not to use that because the federally funded students are already protected. But the non-federally funded students, which averages, each school is different, but it could be anywhere from 1% of the students to 5 or 6% of the students. Those would use this alternative method, or they could just use the surety bond method. Either one is agreeable to us.
Mr. Juneau, does the method, the alternative method, prevent the school from giving a cash discount prepay or a prepaid cash discount? So if I chose to pay for my 900 aesthetic hours in cash, could I still have the school accept that full payment?
Well, it eliminates that because what the issue for the legislature is the non-federally funded students, when they prepay for the whole course, are the ones that take the financial hit if the school should close suddenly and don't have a surety bond to protect that contract. And what we found out when we testified, and the insurance commissioner also validated, that many of the people going bankrupt will allow that to lapse before they actually close their doors, which means there's no insurance available, no surety bond to collect against. So that's where it is, and the legislature was very clear on that. There was a lot of discussion, a lot of discomfort for a lot of people. But the bottom line is that I've talked to both you and Ms. Ditzler prior to you, and I've taken a lot of input. There was a lot of different views as to how it should operate. But it's really a simple decision for the schools. You can avoid it all by just getting a $50,000 surety bond. You're done. Or you can use this alternative method, and you only have to use it on the non-federally funded students because there's no insurance policy against them. The federal government has real strict rules on how that operates. So that's the only vulnerable parties that are with that.
And what's your approximate time frame to make that appropriate adjustment to everybody's surety bond or alternative?
Well, it has to be put in regulation and approved by the Legislative Commission sometime this year. I mean, it doesn't have to be this year, but that's the plan.
So kind of what I'm thinking in the back of my head is the schools that are having like that $400,000 bond.
They don't have to have any right now.
Oh, okay. Oh, with none.
With the repeal of the law, there is no surety bond requirement, period, at the moment.
Okay.
And the legislature wants us to establish a new level. But since there's no new level, no one's required to have one.
I should just add in there that after June 30th, the process changes from making regulations. So if you want to get a draft, it's better to submit it prior to June 30th so that your number gets started. Otherwise, you start getting too close to legislative session.
So we can move on it now.
Yeah, we're going to get it put together next month.
All you have to do is at least submit it by June 30th to LCP.
Now, is it at all possible, since I did move this item to accommodate some members of the audience, that we accept a public input at this time? Because those schools may have some comments that they may want to make.
It's up to the board to do that. Normally we would ask that people talk during the public comment time.
Right.
That's why we have two.
Right.
But
So in the interest of just, please. Okay.
Sorry.
No, that's okay.
So I just want to make it very clear. So the people that have the $2,000 surety bond, that's going away from them.
That's already gone.
Okay, so it's already gone, so there'll be no grandfathered in. It's either the 50 or it's the two choices here.
Everybody's treated the same.
Okay, very good.
Any other board member comments on this under discussion? You know, just in the interest of, I moved this item to accommodate some school owners who have, is there any comment from any of the school owners that are present or any of the public? Please, if you could state your name.
Sandy down in Academy of Hair Design. I just have a question about the schools that maybe choose not to do, it's a choice, either or, bond or not bond. The schools that maybe can't obtain a bond or choose not to bond, how would you monitor they're going to be billing? Obviously, I guess a quarterly basis.
Well,
Quarterly
we haven't
programs.
decided how, we do inspect school records now. We come in and check the hours. We, in the law, it allows us the authority to even charge for an audit if we're not capable of figuring it out. Bottom line is, there's three ways it's going to probably happen. A student complains is I'm not being treated fair, we'll come in and get the records. If we feel that there is concern about how the records are being maintained, we would come in and take a look at them. Or you, for whatever reason, call us and want us to say, are we doing it the right way? Those are the processes. Now, how frequent it'll be dependent on the same thing as we do student records. You don't see us very often, but once a year you probably do see us come in and say we want to randomly take 20 students and look at their records. The reason we do that is because there's a high level of confidence that probably stuff's okay. We're just coming in double checking to show a track record of diligence. Same way with this. My sense is that we're only talking about usually 1 to 5% of students anyway. So we're going to come in once in a while and take a look at the records, and if it looks like that's the way you're doing it, we're going to be happy. If it doesn't look like we're doing it, we may want to see more records. That's how I see it. But until the legislative process is finished, we have time to craft how would we do it. That's the best I can answer at this point.
Hi, Gwen from Gwen Bramo, Expertise Cosmetology. One of my questions to the board and events, with the percentage of taking, from the 0 to 25% using the Department of Education guidelines. So I want to just make sure that I'm clear that since it's either or, if I chose to use the Department of Education's guideline, being a federally funded school, I could.
Well, what you can do is you say, I'm going to put up a $50,000 surety bond as one alternative. If I don't want to do that, then the 5 students I have to use the 25% building process. That is the federal. Read the law. That's what it says. Now they have some other kind of weird layer decision making regarding 50%. We don't want to get too complex. We want to make it very simple. So it's either or.
Okay, and I understand that part, but I think one of my concerns, because I kind of wanted to hear the tuition policy, because with the Department of Education choosing that option, it's a certain refund calculation and a certain time that the money is being dispersed. So it kind of goes hand in hand.
So would that also be incorporated in that alternative payment method? Is the way that student would be reimbursed in the
We have to decide because they are so convoluted. And if you really look at the regulation, it takes a genius to figure it out half the time. We want to make it very, very simple. So the refund policy will have to be something that's simple and easy to understand and be in the contract for those individuals.
Thank you. That was an excellent observation.
Again, since I'm Sandy down at Academy of Hair Design, I'm real confused with this tuition. If the school chose, I probably wouldn't know that. You won't get around with the billing. Plus, all the tuitions usually do it 60%, which that would prohibit you collecting at 60%. Is that what I'm hearing?
Yes.
So why are we having an either-or choice? I mean, what?
Because we were advocating the elimination of it completely.
Yeah.
And that would have solved the problem because we don't believe we belong in a legal contract between a student and the school. But the schools insisted that we be involved with the surety process. The legislature opted to go this way because they felt they were still protecting those individual students that paid up front and usually lost $16,000 or $17,000 in victims. Where the federal funded students, they have a very complex system that they can move the students to other places because of teach-out agreements, and you guys are willing to accept the different students who the failed schools have absorbed all those students. The individual students have never been absorbed. They have to pay again. They've never been forgiven the $15,000 they already paid and never got the money back. They're just out. And that's what the legislature was concerned about. So that's the reason. If it was my school, to be honest with you, I'd use a surety bond process, solve the whole problem, and maintain it.
Any other questions or concerns or discussion? Mr. Jimno, I just want to compliment you publicly. This was a big process, and I know you did a lot of work on this. You and I have met several times. I'm really proud of how it's turned out. I just think you did a great job, and everybody should know that this was very difficult for Mr. Dubna to really work through these and have the discussions that he held with school owners, with board members, with the legislators. I mean, he really, really did an outstanding job, and I really appreciate it. Thank you very much. So at this time, we're going to entertain a motion whether to accept the recommendations of the regulation implementing the surety bond levels and an alternative to maintaining a surety bond pursuant to the SB 183. Are there any motions to that effect?
I'll make a motion.
Please.
To accept the new regulation of SB 183, changes in that, to adopt number one, suggestion and ideas of having a $50,000 surety bond for a school which chooses to acquire the surety bond, or having the alternative method for non-federally funded schools.
And would you then be approving number two, that alternative method?
And we will be approving number two. In addition to three, and for the board to see.
So we do need to do 1, 2, and 3?
Well, she did. She directed the board. She directed the board to pursue one, which she then said that she was approving two, which is the alternative method.
And the joint board also.
Is there a second to that?
I second that motion.
Mr. Hoffman. Is there a discussion on that motion or that second? And just to clarify, Ms. Benaldi made a motion recommending that the board adopt the three options that were presented, options 1, 2, and 3. And that was the motion that was seconded by Mr. Hoffman. Is there any other discussion? I'll entertain that vote. All those in favor?
Aye.
All those opposed? That motion carries.
Mr. President, a little explanation. We'll be going to, what that means is now we'll try to draft something for LCD, and we'll redraft it until it fits all the legal parameters. Then we'll be able to schedule public hearings on it, where this will all be discussed again, and we've been in the workshops.
That's right.
To collect all the information, but we have to go through public hearings again.
Yeah.
So there's a series of steps it has to go through before it actually gets approved, and then it goes to the commission for final discussion.
So we
The schools will see all this stuff again.
You have to have a workshop after you've already submitted it to LCD and got the draft back. So there'll be several more
Before it even
steps.
goes into effect.
Oh, absolutely. There'll be workshops, there'll be hearings, you'll be getting notices.
So we do nothing.
So at this time, it's 12 noon. We're just going to break. Did you have a question?
Yes, I do. May I?
Well, it depends. We don't normally accept public comment except at the beginning and the end of the meeting. So is that what this is about? To address us?
Is it a compliment? It's a compliment. It's like a
Was it relevant to just the prior discussion on the surety bond?
No.
So it's new matter, new business?
Yes.
Will it be able to wait until after lunch?
I'm not sure. It's my dog's at the vet getting his teeth done. So
Well,
once they call, I
I'll
gotta
tell
go.
you what, we're
And
generally, unless Ms. Reynolds is going to disagree with me, generally there isn't time on the agenda for this type of public comment unless it was related to the last issue discussed, which was the surety bond. And so at this time, it's just after 12, we're going to take the comment.
only because I was trying to speak because I have my director here.
And I'm
from-
leaving.
And she's about to leave. That's the only reason
Well, then you've raised your hand.
that.
How do you help you?
I was,
Can we have your name?
Oh, I'm sorry. Tamika Leonard. Tomika. Leonard, Leonard. I'm a student at Marinello's. I'm scheduled to graduate April 12th. And I was a student at SNUC some years ago. And I just wanted to know if there was any way possible I was able to get some of those hours. Only reason I'm asking for two reasons. One, I live in Chicago. I go every day, back and forth, every Saturday, and come back every Tuesday. I just pay somebody to take my trip so I can be here for this meeting to see if I can just get any of those hours, if possible, just so I can graduate next month before my last disbursement check of April 1st is deposited to the school. My graduation date is April 12th, and my son will be coming home from the military, and I would like to have him here so I can graduate. And to me, it's like a refresher course anyway. I'm almost done. I'm less than, 2 months.
Is there a staff member that can review her hourly records during our break? Or is there a staff member that can assist her?
May I ask the question? You say you went to SNOOP?
Yes, I went to SNOOP.
Oh, do you have a copy of your hours, or they're incompleted? They're incompleted
They're
hours.
incompleted hours.
Do you have any records of your hours that can
I
be
have my
audited?
EPC book. I called the board, the financial aid department that handles my loan, and they showed me I did my disbursement check, and I actually even had something from the board because I transferred to Dudley for a short period of time and came back, and they approved those
They don't
hours.
have
as well.
any hours on there.
This one has 160, and I even tried to see if they had something out there.
Again, I'm going to ask, is there a staff member that can assist her?
Let me respond to that. Okay. Snook went, closed its doors. We did an audit for those students that were there. It all depends on a lot of issues. We can't make that decision in 5 minutes. That takes a lot of research.
And that's outside of our scope as the board. That's why we have the administrative staff, is to be able to accommodate your request.
Okay.
So maybe after we break, I'll ask Ms. Curtis to talk with you just privately, and we'll find an avenue for you to have those questions answered.
Well, she should put it in writing, so, or at least tell us what she wants, what she's trying to do versus coming here. I mean, she's got to make application to us so we can say, can we have those records? Can we prove them?
I tried to quote, the deadline was on December 29th. The only reason I brought it up is because after I just did my taxes, I found out how much money I've been losing to come to school, because I come back and forth between Chicago. I even transferred because I like the school out here a lot better.
Ms. Curtis, could I volunteer you to assist with?
Certainly can.
Okay. So at this time, 12:05, we'll resume at 1:05.
Thank you so much.
Thank you.
I didn't even
And the meeting of the Cosmetology in the afternoon has begun. We're starting off with any items that I overlooked or moved and have not gotten back to. We're right on schedule with the salicylic acid. Okay, so if we'd like, I'll just start with that then. I just passed out to you just a quick little summary regarding NRS 644.470.2. And I just wanted to let you know that that law was written in 1987. And then we have gone through quite a bit of regulatory review for that. We started in April of 2006. And from that meeting, it was actually overlooked when we submitted the NRS and NAC changes to LCB. So then we picked it back up again in June of 2009. And that's when I forwarded the FDA ruling to staff, as well as we started talking about it in the two-tier subcommittee. And so since 2010, we've really noticed that salicylic acid is in literally hundreds of our salon products. And in fact, I've asked a couple of the investigative staff, and there are actually products that say salicylic face wash. So they actually even market that ingredient deck. And the reason for the salicylic acid prohibition is because it is what we call a keratolytic, which removes the surface dead cellular debris. But one of the research that came out of the FDA, it's that cosmetic ingredient review, is actually in the third paragraph down, which is the effects of salicylic acid actually do not extend deeper than the epidermis, despite the intensity or the contact intensity of salicylic acid. When salicylic acid is combined with resorcinol or lactic acid, it does become a solution. And that solution is oftentimes referred to as Jesner's compound. And in the recommendation to remove the prohibited use of salicylic acid, that is not intended to allow for the use of the Jesner's compound. The Jesner's compound is actually roughly a 17% keratolytic solution, and that would actually extend deeper than the epidermis. So while I'm making the recommendation that salicylic acid be removed from those prohibited uses, I'm not advocating for like the beta lift peel or the Jesner's compound, which are high intensity compounds. It's not just salicylic acid, but a compound using salicylic acid as an ingredient. And then finally, if you kind of read through to the very end, the last sentence is that cosmetic ingredient review panel for the FDA in 2000, so 13 years after the law was drafted, those clinical studies did indicate that salicylic acid could actually be used in pregnant women and on children. And primarily the applications for those are wart removal, that's the primary application for salicylic acid. And then secondly for acne reduction, because it kind of acts as a little sanitizing solution for folks with acne. And then it has an added benefit of hyperpigmentation correction. So folks who get a pimple and then they have that red mark or the red lesion for a couple of weeks after they've had a pimple, it aids in the reduction of that hyperpigmented scarring. So this is, again, just the research, the findings since the law has been drafted, and then the recommendation that that singular ingredient be removed. And I'll be happy to answer some questions. And you should have actually received this before, the same information.
I would like to comment that since all of this came up, I started looking at all the products in my salon, not all of them, but it is in shampoo, it is in conditioner, it might be down on the list, but it's there. The only time I've seen it actually listed was at the spa, which I had contacted Annie, and I believe one of the inspectors also went over to look at it. But it was for acne, the acne treatments, and it was actually listed on the box for acne treatment. But everything else is in the list of everything that's in the product. It's in products. So I'm sort of tired of I just think it's time that we make a motion, make a movement, do whatever we need to do to change this.
I think it's an archaic law, and certainly not change it. I think research and development of this.
You did a great job with
This
this
law.
researching.
Yeah, so I'd like to make a motion to amend. And ready to go? There's two.
Could I have just a couple of questions. The little bit of research that I did on it, there was a reference to salicylic acid being an ototoxin that inhibits Preston. And then also, you had mentioned the formulas and levels of it. The little bit of reading that I had done on it was with regards to some pregnant women not being able to use it in doses because it causes bleeding in the fetus. Is that where you're talking about those higher levels?
Generally in compounds.
Okay.
Yeah,
So
sure.
where you're talking it above, because the normal skincare products, it's like a 3 to
Like
5
even
or
a
7%,
Yeah.
and then above that is okay. Because that would be my only concern with regards to the public welfare. Is, I mean, I understand that there's been a substantial amount of research and they've now changed. Clearly, it's in every kind of everyday product. But then, I mean, there's a much longer list of what it did to help, which was acne, psoriasis, calluses, keratosis, pilaris, warts, and it's also a bacteriocide, again, with regards to the acne treatments. There's a lot of benefits. My only concern in protecting the public welfare is that little bit of research with that may be antiquated as well, as you said. At above a certain percentage level, you're not recommending that because it's penetrating beyond the dermis, which I think, again, is where we're talking about beyond the scope of what an SLA
of the skin conditions that you mentioned that's where salicylic acid acts as a keratolytic. And a keratolytic is just really removing the dead skin, the topical cellular debris.
But it also loosens the cellular structure to allow that.
For allowing it, exactly. It's like a glue softener.
So can we put a percentage on it?
Yeah, and that's why I wanted to ask that question is, do we make a limit with regards to the percentage of what we allow, or what we think we should allow?
I just wanted to say that currently the law is prohibiting it, so what you would be doing today is going forward to direct Mr. Gimno to work with whoever he needs to get the law changed. So it's not a change, that you can make today.
Right.
Because the law is what it is.
But the recommendation is that the law can change.
Yeah.
Or that we want to put forward in the law.
The key that I would need to system on is tensions, corrosive, sublimates, and what have you, is to first of all identify the percentage that would be appropriate and the wording that would be sure that we're not changing the law to allow unlimited use that you don't buy into. So, Mr. Leader, would you be one that would help us understand how that should be rewritten?
Oh, I'd encourage that. But the reality of it is you're not going to be able to purchase a higher percentage of salicylic acid. It is the lower percentages that really the FDA allows in over-the-counter skincare products. You will only see those higher percentages when you are a healthcare provider and you're purchasing directly from that type of healthcare distributor. Like we wouldn't even have access to that type of purchasing, and that was proven to administrative staff with the Script Hesco. When I went to purchase the Beta Lift, Script Hesco contacted the state board because
I want to be sure we don't open the door accidentally to more serious problems.
And I don't think that you would be able to, and that's why I mentioned very specifically that it's the ingredient itself, and when it's combined as a compound, I actually don't want that to be non-prohibitive. The compounding of salicylic acid is when you start looking at a healthcare provider's scope of practice, as opposed to...
What I was asking, though, is I don't have the expertise to do that.
Oh, no, I'm glad to help. Yeah, for sure. But again, I think that identifying that percentage strength, I think it's almost irrelevant because you would not be able to have access to that.
And this is an NRS, so we would have to wait to the 2013 cycle. We would put it in, and the reason we're bringing these items up now is the governor's office has a May 1st deadline to have things that are going to the legislature under his flag, 100 or so bills that he's allowed. We have to get that in before May 1st.
Right.
Okay, so we identified those areas that we want changes, and we make it all one bill.
Yes.
Okay.
Did you have a question?
No, I just basically, I don't know anything about this, so I have to leave it up to the experts because I'm certainly not expert in this field, so I have no opinion.
My only opinion is since we've been doing it since 2006, we might as well go ahead with it and get it on the agenda or get it so that we can get the law passed and they love it.
Yeah, the history
Maybe a
of it
month
was...
and a half, man.
Right, so
The history of it was as we brought it up, and it was sort of tabled. The second time they referred it to the two-tier committee. It never got resolved. So now we're saying, do you want to go or not? If you do, I'll just put it in. I don't know enough about it to be opinionated on it one way or the other.
Good.
No, I just was going to say that pretty much brings us back to Ms. Rinaldi. The motion she was going to put before they come.
I think it's good question.
Any other questions? I'd like to entertain a motion to accept the recommendation to amend NRS 644-472 to remove the prohibited use of salicylic acid. That's what motion to come to the table.
I just seconded it.
No, I think we were making a motion.
I know, but he just totally So I would like to recommend that NRS 644.7470
to be amended to be removed for the use of salicylic acid, or the prohibiting of salicylic acid.
Does that motion is really made to take salicylic acid out of that provision?
Yes.
But leave the rest?
Yes, sir.
But then also to determine the percentage usage, like you said, if you're talking about medical doctor versus esthetician license. We're good.
Yeah, you won't find that available to us. It's not a corrosive supplement anymore. It's considered a keratolytic. Corrosive sublimate is way up here, keratolytic is way up here. So you won't find that unless it's been compromised. There is actually a motion on the table, so if there's a second, then we can. And now it opens it up to discussion. Sorry about that protocol. Any discussion?
I understand the concern for the percentage, but I just don't think it's not available at all unless you're a doctor. So I think our use of it is incredible.
That was my only
So
concern.
what about estheticians that work for doctors?
I think that they're going to always stretch the boundaries of their scope of practice, and they have somebody else that they're going to have to answer to. It's in our licensing and our scope of practice that we're concerned with, and generally that's considered over the counter. And that percentage strength is regulated intensely by the FDA. We're not going to see it.
Mr. Lee, do you think there needs to be any kind of additional wording that talks about the compounding?
That's certainly something that, the future subcommittee could look into. I mean, it is the compounding. Compounding requires a prescription. So, if a beauty provider, cosmetological provider, were to try to attempt to compound it would appear to me that they would be working for in some type of physician capacity or healthcare provider capacity.
Again, what I'm asking is, because I heard you guys talk about the compounding as the concern.
Right.
Do we have to put some wording in there so the law is easily understood, compounding, even if you could get it?
Even if you could get it.
That's the concern, is we word it so we don't cause ourselves problems later in life. The lack of the right word.
I would still like to proceed with the recommendation to amend its prohibited use and then explore how we would draft that to minimize or prevent compounding.
We're not having too many problems with that. The subcommittee could actually assist in discussing and get wording and then checking with, say, the pharmacy board staff to make sure that the wording we're using will be applicable properly, so we're avoiding the medical conflicts.
Right.
And we're not providing the authority for people to use it for facts.
It's almost like we would almost write an NRS 644.470 like 3, if you will. Like right now there's a 1 and a 2. We'd almost
Take out the word salicylic acid with the number 3 that says it's prohibited to use
as a compound with
with
other ingredients.
Okay.
That would probably be, I think, the best way to kind of make that NRS the most successful.
Yeah, that's great.
Because it is in its compounded form, and it does say or compounds in item number 2, derivatives or compounds. But I think it would actually probably have to be expressed. Is there any other discussion? So the motion on the table is to amend 644.472 with the second to that. But I do want to make sure that when we do our voting, that there is a supplemental request that we further define the compounding of that ingredient. Is that clear to everybody? Yes. So I'll entertain that vote. Those in favor? Aye. And those opposed? That motion carries, or that recommendation carries. We're moving right along to the discussion regarding the tuition reimbursement policy. And mistakenly, I had assumed that this related to the schools, but actually this is our board tuition policy. That's actually found in our employee manual. If those of you who don't have an employee manual, you're welcome to request that. And the educational assistance policy is number 314. It's found on page 49 of our manual. And currently, no employee will receive more than $1,500 in a calendar year. And if you've read the tuition reimbursement policy, the item number 2 was raising that amount to $3,000.
Mr. President, currently we only have one student that actually takes advantage of this, Miss Nadine Griego. She's been taking computer technology courses, and she is more than paid for the amount of money we've invested in her. She's currently on the track to become a full systems engineer. And so the issue here is $1,500 doesn't cover much nowadays. So what I want the authority to do is raise it to $3,000 max cap. And that allows any student, any of our employees who've been here for 2 years or more, would be eligible for free and approved classes to get up to that amount. It's not a big expense for us, but it has paid off. This is an internal policy that the board is sponsoring, ways to encourage our own employees to be more valuable to our organization.
Also, Mr. Jimbo, as part of that policy, it appears that never mind. Pardon me.
There was a couple of old archaic approaches where they wanted you to give the books to the local community. They don't really want them. And the books change so fast now that once the course is over, you're lucky if you can even get back to school. So we're not going to require that, and we want to broaden the scope of the schools they could attend as long as they're pre-approved for the reimbursement program. And that is, the list that was drawn there was drawn picked from plucked from thin air because it was the most obvious one. Nobody had done any real detailed research on it. So we've broadened that a little bit, but we still retain control to make sure that it's not basketball being, out of big carrots.
I'd like to entertain a motion to approve or deny the tuition reimbursement policy.
I'd like to make a motion to approve tuition reimbursement policy.
The new tuition reimbursement policy. So there's a motion and a second. And to clarify that motion, it is increasing the reimbursement from $1,500 to $3,000. That will also amend the employee manual and make the employee manual current as of 2012. All those in favor?
Aye.
All those opposed? That motion carries. Tuition reimbursement policy.
Do I understand the second part of that?
I'm sorry, do we have to vote to eliminate donating the books and so forth?
Just adopting the
Yes,
I
the
think
new
if you're
policy.
adopting the recommended policy, that adopts
That doesn't have to be
everything.
in the motion.
What I want a clarification on is, Mr. Leader said something at the end of this.
Oh, it just makes this, it changes the dates of this.
So we're really, basically, you just approved the manual for 2012.
Right.
This won't change.
With that, yeah, well,
There's no
that
other-
change
There's
will,
no other changes in
not that I'm aware of.
no.
Okay, not that
Got
I'm
it.
aware of.
Understood.
The next item for discussion, we had moved the surety bond to the previous morning session. So discussion regarding the possible NRS changes.
Well, we have the retreat.
Oh, the retreat. Oh, way back up there. Good grief. Skipping all over the place. Pardon me. Those of you who know that we've done a retreat in the past, it was very effective. It was one of the best things, particularly for me, to understand the responsibilities of a regulatory agency and also how to effectively communicate with the executive director. When I first started on the board, I was a very ineffective communicator when it became time to address my concerns with administration. And it was only after the board retreat, which was very humbling, but also very valuable to have just more successful relationships with staff. And there have been a couple of things with the board that I thought would be very nice once we had the 2 new members, and that was the 3 items that are part of your background here. Just making sure that board members understand how administrative hearings work, and if there was any indication with our first hearing this morning, we all need a little remedial training, particularly the board chair, president. So I would like to advocate for a board retreat once our two new members are on staff. I don't necessarily feel that a board retreat prior to those appointments would be as effective, but I'm certainly open to discussion regarding that. And then perhaps we did the last one in the South, and perhaps depending on what you guys decide, we may be interested in doing that in the North. So we'll have to entertain some. But how about any discussion on the board retreat?
I think that's a great idea to wait till the new board members come so that we're not wasting funds.
Right.
And they do get in on the training with us, and we'll get to know them a little bit better by meeting at a retreat.
Sure. Are we planning 2 more board members?
2. The other thing I'd like to talk about too is at that board retreat is the inspector's manual, because the staff has devoted an intense amount of time on that inspector's manual. It'll be really a valuable tool to have Mr. Jimno highlight some of the key characteristics, particularly for the new board members. I think it'll be a great opportunity.
The issue of this meeting was to try to, if we're going to do it, first of all, do we want to do it? And secondly, what are the kinds of topics other than what we've done before? What brought up the inspector's operations manual, here's a copy for you to look at. We're working on this, Alexander is working on the licensing operations manual now. That's a little more complex because of the Versa computer system, but it's going to be fashioned similar to that. And I know that one previous board member had mentioned about how come we don't do that, but it was almost, that one was done, and we're in the 2nd phase of it already.
I thought that the meeting we had in D.C. was very effective, and I think it brought a lot of people together, and you get to talk about everything that's concerned, a lot of things that we don't bring up in the board meeting that we can talk about. And Vince had given us a lecture, and it was good. He gave us a test. I remember that one. And it worked out great. I think it was a very good thing to do.
And also inspirational messages. I mean, I think that that's really one of the key characteristics that Mr. Jimno has brought to our board, is not only to empower us to do a better job, but I think, Mr. Jimno, you inspire us to be better, not just people, but just better at what we say, and making sure that our actions match what our intents are. And I think it would be an extremely valuable retreat if we included the way that the office staff have you done the timelines on job tasks. So going through job tasks could really open up our eyes to the level of responsibility that the staff has.
We did a formal workflow program.
Thank you.
And we also did a workload analysis. So those might be an interesting topic for you to hear. How we figure out what we do, and how many widgets we can handle, how long does it take for each widget, that sort of thing. To get a sense of how complex it is. One of the things that Ms. Ditzler has indicated now that she's in the trench, she said it was much more complex than I ever dreamed it would be. And so that might be an interesting discussion. The other discussion we might want to go through is a repeat of the open meeting laws, and should we truly understand that, the conducting of hearing procedures and the requirements, because those are a little more complex. We tend to forget after a while. Are there any other topics you see that need for this time?
I think I was talking with Sarah, doing one on
really understanding how it works when we get the citation in front of us. Because there was one that I was extremely confused on today. I understood, yes, I understood the basics of it, but I think I would like to look a little more professional up here and understand it better, I think.
And that's 622A?
In part, I think what you're referring to is the complaint notice of hearing, and I could actually give you a sample one, and we could talk through all the pieces of it and why they're there and what they mean. I mean, I don't know if that's what you mean, but then you can see, like, for example, we have to lay out facts and jurisdiction and alleged violations, and here's your options of what you can do, so that way you know where everything is and why it's there.
Well, realistically, we don't want to wait for a retreat to know that. So.
I just thought that's not something that we did last time. I think last time we talked about how hearings work in a more general sense, and maybe as part of that discussion, I could bring a sample and we could go through it, and you could ask questions maybe.
And even maybe provide us with an outline. I mean, I would like to understand it better myself because I would like to look a little more professional.
And Rosemarie and I were talking about possibly doing like a little sample hearing, where she could be board counsel, I could prosecute the case, you guys could decide it, and then we could have, I think Monica would probably be there, she could be the respondent or something, and then we could practice some of these things.
So what we want to talk about a special meeting for that, if that's important. The retreat might take, we may not get appointments for the next month or two or three, so the retreat's going to be later in the year.
Right.
And I heard what I think I heard was, we'd like to do some of that earlier.
Yes.
That would be great.
A training session of some type.
Yes. So perhaps I'll entertain a motion, and it could be a two-part motion, to have maybe a future board retreat, but a more immediate board training. If someone were so inclined to make a motion to that effect.
I'd like to make a motion to plan for a future board retreat and also more immediate board training.
Are there any discussions to that? And I'd accept a vote on accepting, or I guess those in favor, say aye.
Aye.
And those opposed? And that motion carries. So we'll just direct administrative staff to kind of come up with a date for that.
What will happen is Mr. Leader and I will talk about possible time frames. What happens, do we want to put on an earlier training session specifically for specific items that you guys just talked about? So we will do that. We just wanted to know, are we going to plan a retreat? Approximately when we should do that. So Mr. Leader,
and it sounds like we're probably targeting the north.
That'd be fine.
Yeah, because of the county
That'd
government.
be nice.
We did it off campus last time. So
Yeah.
That's
North as in Northern Nevada or north as in Montana?
Hawaii, isn't it?
Hawaii's north, isn't it?
It's like
No,
a
south.
Hawaii.
South.
Yeah. Okay, so now that brings us to 15. So perhaps laws, possible NRS changes by the board.
This is what I want to do, is identify any NRS changes you want. I need to put them in this memo and request from the governor's office for a bill draft request. So we need to identify any NRS that we want to include in that.
I have one, I don't know how to do all of this stuff, but I'm the one that I've talked to you about having a school that's smaller for such things as makeup, and I know that becomes an NRS change, because I think it's really important to, since we have so many people that work in the industry here in the hotels and shows, and that we have more movies done here, is to be able to have a smaller setting so that somebody can come in and teach makeup classes and not have to have 5,000 square feet. You would certainly need that many for advanced students. So how, I know you said I had to do something, that's something I was going to talk to you about.
We would have to do an NRS change to change the definition of the school or add another category that the board would have the authority to approve schools less than. So So that's a wording thing. Do you want to do that?
So that is NRS 644.387 and NRS 644.400. And making adjustments to those NRS could provide for smaller places for school instruction or even postgraduate instruction.
Yeah.
It could also allow for a singular professional license training.
What was the number?
NRS 387, or 644.387, and NRS 644.400. And what that will do is it will allow for some folks who have come before the board who want to teach in their salons. It could also allow for a makeup artistry school.
So the issue for me is, do you want to, they can teach classes in a school. Some people want to teach in a salon. Some want to teach it in a separate room. So we need to know, I need to know more clearly what you're asking for. Because those are NRS changes that require a few words here and there or elimination of a sentence. But I need to know clearly what it is you're after.
How I first see it is that it would be like a graduate school or an advanced school, like with makeup. If you're doing makeup, you're going to have your models that you're working on, and you're going to be coming back day after day. So you would need a school. You couldn't do it in a salon, a makeup. I think there needs to be a category for.
I understand where you're coming from.
Okay.
That's not a problem for me.
Okay.
The other thing is, does the board want to approve courses that are approved by the agency after we look at the curriculum, quality of the instructors, and the materials we're going to teach? And if we approve it, it is allowed to be outside of the school. Currently, there's some language issues in the definition of where you can teach a class. Now, I'm more of a liberal thinker in that sense, that I like a broader definition, but there's a few words in the law that we have to change. And Sarah's aware of a couple of the sections that we've discussed in the past. So the issue is, do you want us to really entertain that? Because we won't have a chance to come back to you when we submit the bill draft request to the governor's office. But I can work with the president and a couple of you to make sure I've got all identified those changes.
I certainly would like that.
I can understand what you're saying.
Remember the couple that were in Reno?
Yes.
Now that was a perfect example. I felt like it included something that maybe we shouldn't have. Are they teaching outside? Are they teaching in their salon? What are they doing?
They wanted to teach classes outside of the salon. They originally said into the salon, but they later said outside the class, but they would not use human persons. They would use mannequins. And so there's a definition dialogue going on between staff members about whether that's allowed or not. We've drug Sarah into that dialogue a couple of times. And there may be a couple of words where you could go either way, but let's go ahead and fix the thing once and for all. So that's what I'm asking. The case on the smaller school, we've had 2 requests for smaller schools for. An example was the Belgian lady that wanted to teach advanced aesthetics, only 20 students, fully be a regular school, except it wasn't going to be 5,000 square feet, it was going to be 3,000. And we turned them down on that definition. So that's one of the issues. That would be our makeup artistry programming, that the schools teach basics, but they don't teach advanced.
We've also denied requests to the International Dermal Institute to provide student hours when they attended their facility of education way back when, if you recall that. So that would
Those
also...
are the kind of changes.
Now, I'd like to say, I think that we want to include other than just mannequins, because I'm going to be an example. I have coarse hair, my hair stretches when it's wet. They quite often use me in schools as an example. And I think sometimes, and I'm sure people have other different problems with hair, real fine hair, you have to be real careful with the cut. You can't learn that on a mannequin. You really need to learn and see that. I think and touch it. A lot of us are in this discussion are touching
The
type.
philosophical problems we're having is the schools are not teaching any of that stuff.
No.
So there's no place to go get it.
Right.
And so if they were, I could see the issue being it's a matter of marketing. But they're not offering But the way the laws are written is protective oriented. So only the schools can do it. But they're not meeting the market's needs. So the issue is, and the governor's staff has been preaching for quite a while now, we should be making sure our laws and regulations are not prohibitive to do businesses that we approve of. And so that's what I'm trying to identify, any of those changes.
And you know what I can see, that's too, they have some of these new salons, they're called Solera, or am I saying that right? Yeah. Yes. They could put a school back there and actually do a space where somebody can come in and use that room as a classroom and be able to do some of these things. I think where it becomes prohibitive for these people is when we say you can only use a mannequin. Because you actually need to be cutting somebody's hair or showing how cut to go.
Are we talking about more or less continuing education?
Continuing
So this is
education
people that are already licensed to
Advanced
further their...
education, yes, is what I'm talking about.
Annie, you have a comment?
Okay, I think I'm hearing when you're talking that you're talking skincare predominantly, but I think the board needs to be aware that if you open up a smaller school, there's also been the need of people that want to do nails in an extended way, and they want to do beautification of the acrylics, and it goes deeper than just the skincare. Then you have the breakouts on how you want to do braiding and how you want to do this. So when you entertain the smaller, you're also talking about anything that's under the umbrella of the whole cosmetology.
Absolutely. And I think anytime you can enhance somebody's education and get them educated to be a much more professional person, it's going to increase their income.
But you also have to make sure that you're going to have what you're desiring is to have someone teach the correct stuff, because the job of the board is the protection of the public. Right. So how are you going to incorporate that to make sure that you get that also?
It's going to have a significant backlash from established schools because you're going to see you trumping on their territory. And so the issue is when we open it up, we open it up in a very careful way that it doesn't present that.
More than I think licensure is the clearest path towards defining what that may be.
Yeah, that they have to be licensed already.
And that way it's not a threat to schools because obviously it's licensed. They can retain any school.
Truly to be in advanced classes, you want your basics in school, like grammar school, you get your basics and you go on to college.
In 2007, we had where licensees could teach other licensees in a demonstrating fashion. It was licensees teaching other licensees things that they knew, and they could do that anywhere. Or they could do it in the salon, and they could do it outside of the salon in a specific area. But that was repealed in 2007. But it gave the ability to teach and cross-teach on anything.
Yeah, right.
Demonstrations.
What happened to that?
It was repealed in 2007.
So now you have to be an instructor, that's correct? To be able to
No, you have to be an instructor in the school. You can't be an instructor freelance.
So then, I think that brings us a point then that you have to make you can't be an instructor because you can only be an instructor in a school. Then there has to be some criteria set that this person has maybe so many years in the business.
We have criteria that talks about credentials of instructors for anything that's taught. We have to see the curriculum, and we have to know. We do this for continuing education for instructors already. It's real easy to establish what will be acceptable. It can't be just anybody. It has to be people who have been an instructor, or they have a degree in the field. If you're talking about diseases of the scalp, a doctor would be qualified. But Mary Smith, who combed hair twice, would not be.
So it would be like on a case-by-case basis?
Case-by-case basis. But the issue is some laws have to have simple rule changes to allow us the flexibility of the law to do it. Annie brought up Ms. Curtis brought up one of the laws. There's 5 words in it. And you can loosely interpret it, or you can change the law and fix it once and for all. It gives the board authority to do it, but not necessarily demand to do it. It just allows us to make the call. Now, I don't see a problem with that. I mean, any school like that would be brought before the board to to get approval, or we have a procedure that's approved that would make it automatic for us to make that call.
I want to note, too, that we don't have to reinvent the wheel on this, because even Florida, they have an approved provider system in place, and so we can access our other state boards for advice and even, forms, if you will, and Mr. Jim knows well aware of that. I would also like to move on to NRS 644.331. Right now, that's currently the registration of individuals that touch customers, and I'd like to see that explored as being a license. This is a two-part question. That's the threader. 644.331.
That's ready?
Yeah, that's the registration.
The legislature stuck that on us.
Right. And I'd like to see that amended to, threading isn't depilatory. I've mentioned this to people before. It is hair removal. That's what estheticians are licensed to do. So to circumvent my license, to give someone else the opportunity to remove hair is not an appropriate thing for me.
So let me ask
So
you.
I would like that NRS review.
Let me ask you a question. What you're suggesting is putting the NRS change back in the system to overturn what the legislature did.
I would like to see that a licensed practice, not a registered practice.
I just want to know what it is the board wants to do with that.
I'd like to take a look at that one. The other part of that concern, and Vince, this is when back last February, the LCB requested that we submit the letter with the 5 points. That's noted in the law. But I would like to actually see this year's letter drafted, even though it's not required. I'd like to see a letter drafted from our agency to, it goes to LCB. Yeah, it does go to
That was
LCB.
part of the law in 2011,
Right.
the request.
I would
was to
actually-
say, what kind of reaction did we get? What did we do?
I would like to see this year's letter drafted that talks again about these 5 points and reiterates that threading is a depilatory. It is hair removal, and that's why we are licensed to do that. We're not just registered. This is a small group of people that are skating by, and before we have a problem with registered folks, I would like the LCB or the legislators to realize that currently I'm more interested in having that licensed, not registered.
Understand that we'll probably get a backlash on that.
Right.
Understand. The other thing is some states that's what they're doing more and more. That was put upon us by the hard lobbying done by the particular people who want the threading to become uncontrolled.
I have one other too that I think we were going to hear it in the one case. Why can't a barber be in a beauty salon?
Well, they can't. They just are enclosed and separate.
Because to me, I think
answer that
what's the
for
big difference?
Because they have to have their own space, they have to have an enclosed room, because they're cosmetologists. Is that what you're talking about? Cosmetologists in a barber shop?
Why couldn't a barber rent a place from a booth?
First of all, there are 2 different boards, and customarily, the barber board has never wanted to be with the cosmetology board. And they've had lobbyists of the legislature consistently to make sure that they're not incorporated with us.
But if we wanted to change our laws to allow a barber to come in and rent a space,
They don't want to be in. They have a law in our book that says that we cannot predominantly do men's hair. 473. That was put in there because of the lobbying of the barbers.
and who's counting?
Well,
No one
the
does.
barbering board is being reviewed by the Sunset Commission right now. So it may be a mute issue.
It just seems silly to me. If I was a salon owner, I had spaces to fill,
and a barber came to me and wanted to rent a space, I would consider that everything that I did in my salon, he would have to do in that little cubicle also. And it would be healthy and safe.
It has never been a fight of the cosmetology board.
Okay.
The barbers are the one that oppose.
I just thought that was, but didn't we just write somebody on, didn't somebody just get written up for having a barber in the salon?
Yeah, the tax salon.
The one that didn't show up.
Yeah, how come we wrote it up then?
They weren't separate.
A barber working in a cosmetology salon is the same as an unlicensed person under our rules.
That's what I'm talking about. Well, I do we have that rule. That's so
Because
the
barbering board had it installed.
They installed it into our rules?
Can we change that? Can we go?
I doubt it, but you can be a barber and a cosmetologist, you can only post one license. So there's a number of cosmetologists who are also barbers.
So they have
their
dual
license,
licenses.
but they post their cosmetology.
Right, so that they don't get.
I mean, I'd love to.
They do them in clients. It's just their cosmetologist.
I just think it's a business thing. It has nothing to do with the cosmetologist or barber. They should all be treated the same. You should be able to allow in your salon, if you have that license.
We're not the legislature. That's the problem.
Want me to go talk with them?
Yeah.
The Board of Barbers has gotten to push their personal agendas. No, so they're not mixing them. They don't want to play in our sandbox.
There's always the possibility they will be folded in whether they like it or not. Sometimes
They should be.
Well, if the Sunset Commission comes back and
recommends
like we were talking about, they may be under our providence sooner or later.
Should we prepare something in case that happens and we're ready to go?
Well, we already
Amend this
reported to the legislature and the governor's office that our agency is highly capable of absorbing other responsibilities.
Oh, yes.
And that's the clear message that they picked up.
We have a
And
barber.
Mr. Hoffman obviously knows about that.
Make sure nothing ever got mixed.
But that would be something like
So
that.
that's the holdoff then. If you can get to work on that school thing for me,
In your free time.
Okay, any other items? So what we're going to be doing is the staff and I are pulling together those questionable laws to make corrections and making sure we understand what board members wanted as part of that package for legislative change. So obviously the president of the board will give me the final okay whether this is okay or not.
The last item is there a fee for the Nevada law test?
Not separately, and the legislators basically told us no fees in the future. When they release us of that, I don't know, but what we're saying is that the law test will be included. If you fail it, you pay the whole fee for all the retests, even though you only failed one part, because we don't have the ability to change it.
So NRS 644.220 should reflect that the Nevada law test is a two-part written test.
It really basically says, and I think something to do is more generic.
Okay.
It says, and any test required by
Any test. Thank you.
includes all three tests. We have practical, written, and law test. And basically the philosophy you presented to me was all new licensees and all licensees from other states have to qualify for that test.
Correct. Any other discussion?
I just wanted to, so we're wanting him to amend which NRSs, was there any NACs? Quickly, which one were the numbers?
I think it's 420, 430 rather. I can't remember.
644, 387, and 644, 400.
400, yes. There's also NRSA 644.270, I believe. That was one of the wordings on salicylic acid. 331, the registered hair, it was a repair of the threaders issue.
Yes. And I do want to remind you, since we're there, that the definition of threading, NRS 644.0295, threading means to remove superfluous hair from the body.
And that was
Why that's
explained in
licensed.
detail to the legislature.
What was that NRS again?
All right. We're moving along to the treasury reports for September, October, and November of 2011. Did everyone have a chance to review those or have any questions or compliments of Ms. Lasko?
Well, we've got one year.
I appreciate that they always balance.
We should.
And so I'll entertain a motion to accept those reports.
And we can accept the financial report.
And all those in favor? Or any discussion, pardon me. All those in favor?
Aye.
Any opposed? Acceptance.
Director's report is self-explanatory. I'll add a couple of items to it. The first one is we got a card from the people who had the Region 3 or part of the Regional 3 team group who put that thing together. I thank you, card, for coming. And then we're at the request of the president of the board. We redid the mission statement, and we're going to hang a copy of the mission statement in this room, the lobby, and the lobby up in Reno. That's a framed form. The other thing is we're full staffing. I'm in the process of not accepting one individual for continuing on not performing at a high enough rate. You'll hear more about that shortly. Nothing, no animosity or anything. It's just that she's not doing her job. There's no reason for us to continue with someone who's not going to meet our standards. Otherwise, we're at full staffing, and we may be short back to full staffing again. Everything else is going pretty well. The project that Ms. Alexander's working on is the same thing you saw in the manual here, where the procedural manual includes how to use the computer system, training bulletins, policy statements, and practices on a routine basis that they should conduct. So when you get a new employee, they know what the system looks like and how to learn it quickly. When Ms. Ball was hired, we used the almost completed operations manual that improved training, made it a lot easier to come to speed. And it also tends to solidify policy decisions that don't sort of evolve by creep. You know, they move from one color to another over a period of time. Everything else is running pretty smooth. We are starting down the process for putting all those regulations that we have to complete now that we're frozen back in the system. We have conducted 2 workshops for the certain number on the surety bond. Ms. Bradley says we have to do the workshops again. I don't believe that's true. I think the workshops have been done that are recorded. We now have to submit the findings of those workshops to LCB and hold a 60-day period before we can have any hearings. That's the step we're at with some of them. Others, we have to package them and send them to LCB, and then we'll be holding workshops and public hearings and adoption hearings. The hope is we get everything in ready before July 1st, so it'll all be processed before the law is changed again. That's all I have.
You know, again, I want to compliment Mr. Jimno because there's just a lot of baskets that you're balancing all at the same time, full of information. It's nice to see that the timelines are kept and met. And this year, because of the May 1st deadline with the governor's office, you know, there's a lot of balls to balance. So, again, I appreciate you managing that very effectively. As part of the director's report, there has been a hiatus for the 2-tier licensing subcommittee meetings. And so both Mr. Jimno and I were interested if you wanted to set a meeting date for after the Reno board meeting, if you wanted to after the Reno board meeting.
There's only 2 right now, you and...
Yeah.
Right.
So you wanted to sit for a few minutes?
Is anybody else interested in becoming part of that?
Maybe it's the 2-tier subcommittee meeting. Would anybody else like to be a member?
I'm manicure, so I'm really not qualified to be able to sew heel. Cookie and I neither really.
Cookie, you'd be a great member. I mean, you'd be a really awesome member to have because you are a public member. So when we talk
If
about
I could be help, I'll be happy to do it. That would help me more.
and that could let you off the hook.
Oh, good. So you can go out snowboarding.
Would you be amenable to maybe just a less than 1 hour meeting in May?
I'll be happy to do it.
Mr. Lee, there's one last thing I forgot to say. Testing contract is before the Board of Examiners tomorrow. That's why I'm following up this afternoon with you guys to go to the tomorrow morning at 10 o'clock. Our contract is up for approval. And our lobbyists, whatever it was they didn't like I did, I have to start from scratch and redo their contract. So I'll be working on that. Hopefully we'll have that next time. Department Administration. The form we use is old form. We like the newer form. It was expired before you got it approved. You had to have it started by a certain date or they won't approve it. There's a lot of technical.
So, just out of curiosity, since we were talking about testing, the little...
No, right now. So I do want to just clarify that the agenda will be posted for the subcommittee meeting for subsequent to the board meeting in May in the Reno office.
The question I had, looking at the board chart here for what's going on with regards to testing, just out of curiosity, the written tests, like in Northern Nevada seem to be like 1 in 20 failing, 1 in 7 failing, but then in the South, for some reason, the written test is as much as 1 in 4, 1 in 3, or even half of the class are failing the written test. Is there something that's going on with that? Like, it kind of just seems to be, it's kind of more in the South, it's related to the numbers.
It's primarily people who are trying to come to Nevada, who claim that they're trained, but just not
But
passing.
not even
Mostly nail technology, good candidates.
Cosmo.
Yeah.
There's some cosmetic too.
Yeah. That's what I saw was mostly cosmetology, and I was just wondering why that was happening. So, yeah, they're trying to say they're proficient, and they turn out not to be. I guess that's
The ones that are trained in Nevada should pass. That's the school's fault if they're not training them enough to pass. It's not our job to get them passed. Our job is to test them to see they're qualified. And so a lot of it has to do with what the schools are going to. Nail technologists, a lot of them are trying to, as we've said before, longer their
So they're trying to get reciprocity.
yeah, and they were registered instead of licensed in other states, that kind of thing. So they come to enforcement, take the test. They've never passed the test, they've never taken the test.
Okay, that was my question.
And Ms. Alexander, this report is awesome. And I hope that it's as helpful to you in preparing it as it is for us to review it.
Yeah.
Because I love this pass-fail report. I love it. And I know you worked really hard to get it to a point where I love it. And I really do. Just think it's great information when it's laid out this way. And I think Mr. Hoffman noted that, he was able to see very clearly that type of information, whereas about a couple of years ago, it wasn't as readily clear. You've really customized this report. It is your...
I have to give credit to my staff, Anaya. She prepares this report, and we actually work on it together. I go over it with her to make sure our numbers and stuff match. But this was, this format here was designed, I think, by you, wasn't it, Debbie? No? Anaya. Anaya. And so together I just go over the numbers to make sure they're right, but she keeps all the information of, how many students we have come in, how many pass, how many fails. And I oversee it to make sure, I go over the numbers. So
Well, I hope you'll express to her my appreciation, our appreciation, because it really is. She does a great job like that.
Okay, I will tell her. She'll be glad to hear that.
Question on the discussion here. For Mr. Green, how you guys are doing the new computers, and gosh, they look really nice to read. How are they going for you guys?
Computers are really the life cycle. They're very efficient. The time as far as filing, record keeping, just having information in front of you out in the field really makes a world of difference. We have the citations now, part of the computer package. So we used to have to use carbon paper and, be balancing that and trying to do 3-4 copies of things. Now it's all computerized, we print it out, and thankfully everything is running smooth with that.
And Reno, everybody's on it full 100% now? Oh, good. Thank you.
Do I need to make a motion or have a motion made to accept the testing reports and the chief executive?
Just receive, usually what the board chair does is just takes a minute to receive those reports.
So that those were received and discussed. Thank you very much. And actually, Ms. Curtis, this is something that came up in our Dallas meeting with the NIC, is there was a round table discussion of however many folks were there, 100 folks, and Nevada was the only state that had 90-day inspections and 180-day inspections in our rural communities. And in fact, several states indicated that they inspect less than one time a year. And one state, and I believe it was South Carolina, said that the last inspections were 5 years ago.
Wow.
So
We hear that all the time.
I really appreciate how our inspection staff, and people came up to us at the break and asked how our inspection staff of X number of people were able to inspect X number of establishments. I think it's about 2,500 establishments with 9 different inspectors.
2,200, just under 2,200 establishments. And we have 4 field inspectors, and Mr. Green does other tasks besides, and 1 chief inspector. So it's a marvelous amount of work.
Yeah, and so kudos to you because we looked really good when we were in Dallas presenting those statistics to other states. So thank you again.
Very good.
Mr. Chair, election of officers next. We need to take individual officers, first your position, then the vice chair.
Okay, great. So, election of president and other board officers. I've been happy to serve as your interim president for the time being, but I would certainly be receptive to...
I would like to make a nomination to propose that Alex Dieter be the president of the board.
I'll second the motion.
Are there other nominations? Would anybody else like this hot seat? Because it's hot right now.
They expected me to do it like this, or just close the nomination.
Yeah, the nominations are closed. All those in favor? All those opposed? Thank you. That motion carries. I'm happy to serve as your president for the remaining of my term. There is a vacancy for the vice president position, and I'm happy to accept nominations for the vice president position. Does anybody?
I would like to, Neil, I'd like to second that.
So we have a first and a second. Are there other nominations for the vice president position?
Hearing none, nominations are closed.
Mr. Hoffman, in the event that you've been nominated, in the event that we elect you, are you willing to accept the duties of the vice presidency?
I don't know what these are.
Well, filling the responsibilities of the president. I highlighted that for you.
In the event of assassination, I'm supposed to take over.
Yes.
Make it
Yes, I'll always have the nomination.
There's your duties.
Too easy.
He doesn't even want to. I'm happy to accept votes for Mr. Hoffman to serve as vice president. All those in favor?
Aye.
All those opposed? Mr. Hoffman, congratulations on your post.
We were pleased to see that retainer treasurer responsibilities because we're used to her questions.
So we do have an executive committee now, and so there will be some responsibilities associated to that. We can see this class. There are comments by other board members and future agenda items. I do have one, Mr. Jimno. Pursuant to your NRS 644.160, that's that biannual report to the governor on even years. That's going to be due by June 30th. So I know how you like to juggle your, I was going to say juggle your balls, but that's not going to sound good. So,
Now I'm at a public.
it's 644.160. And so I just would like to make you aware of that, as I'm sure you already are aware of that. Are there other future agenda items?
I would like to, and this is time to comment on Dallas. As you know, we had a conference in Dallas, and I do say so myself, you have been very proud of us, Vince, because we had people come up and compliment us on how professional we were, how great we ran our board. I mean, it was just amazing. I don't think we've ever had anybody come out and say the things to us that they did. And the letter that we got thanking us for helping them was because people just kind of sat there and said nothing. And our president, Martin Lee, would speak. Yes, he did. He spoke. Said a lot of good things, and it was a great thing. I really was really proud to be part of the board at that time. And she was at that time.
Okay, so much for you.
Yes, so, yeah. No, but it was very good, and while we were there, we discussed the fact that we would not have been able to handle ourselves as well as we did, and we haven't had you goods. And I want you to know that, and we also told that to other people. The reason we were where we are is because of you.
It's amazing how leadership has really transformed the Nevada State Board of Cosmetology in comparison to the other boards in the nation. Currently, there are fewer than 12 licensed estheticians on state boards in the nation, and there is only one licensed male esthetician president of his state board in the nation. So that should be public record.
Yeah, a lot of spare time.
Yeah.
And another big thing that they discussed was tattooing, because different states are now doing the umbrella, and the tattooing is coming under cosmetology. So there was a lot of discussion on tattooing, and not just the permanent makeup, but also the tattooing salons. So they were asking us how we handled it, and we informed them we didn't handle it. But it was quite interesting, because that was probably the main thing that they discussed, I thought, was the tattooing.
The whole last half of the second day.
That was all about tattooing and how the different states would handle it, and we automatically said we would have a committee, and of course Vince Jimno would head it up, and he would.
The thing that we have in this state is it's left to the counties or the cities to control or regulate until the state decides what it wants to do with it. We fully thought in 2007 and 9, and even in 2011, we might see tanning and tattooing come to this. Not that we were lobbying for it, but it just seemed like the dialogue was going on. It didn't come about. So tanning got a law passed. I don't know who regulates it. We just did. And I knew tanning, tattooing, and
It was also surprising how many states are deregulating the cosmetology and
We're trying to.
are trying to,
They
yes.
haven't been successful, but they sure made inroads.
Yes.
The one that I found particularly surprising was the state board that wasn't given any information from their executive director as to what it was doing,
Yes.
implementing those issues.
And just as a point of clarification, and we should really keep this in mind when we do talk about tattooing, is nationally there is a distinction between micropigmentation or permanent cosmetics and artistic tattooing. So there is a clear distinction with state boards that micropigmentation may belong with the cosmetology, the regulation that cosmetology provides, but artistic tattooing, the decoration of the body, may in fact remain as by the health department.
Columbia just was given that under the cosmetology board, so Richard. they were discussing on what states were members of NIC and what states were not members of NIC. And so they had a picture up on the screen, and Alex said, well, what are the white ones? And they said, well, these are places that are not, these are states that are not members. And Alex goes, Texas isn't a member? Well, why are we here in Texas? And Texas got a little offended. They were there, but evidently they used the NIC test, but they were not members. So they got a little offended, and then Florida, where our NIC test was last year, they also were not members. So we were informed as we were leaving that they weren't, that they were both joining. But this one here.
So,
So two of us, they have new members.
yeah, the hard way.
Yeah.
General public comments or staff comments?
You guys be quiet.
Anything pertaining to what's happened today prior to closing? All right, well then, absent any further discussion, this meeting of the State Board of Cosmetology is adjourned at 2:00.